If I may humbly submit, Your Lordships.
10
This is-
decision, at least 10, 12 decision, I recollect, I have quest.
Your Lordships, if I may humbly submit, there is a larger issue of the institution involved, Your Lordship.
Except that this bar field rule of convenience.
Your Lordship, this is not at all a matter of convenience, Your Lordships.
That principle of convenience, that is what very religiously followed by the bar, Supreme Court bar.
Your Lordships, if I may submit,
Whether it's of tribunal, whether it's of district court, whether civil court, of the high court.
Your Lordships,
Yes.
if I may just say one more line, the basis for the notice, Your Lordship, is an alleged resolution that the former Chief Justice did not have the power, Your Lordships, to create their posts.
That
Your
I
Lordships.
can hold it.
Your Lordships, the Honorable Chief Justice does have the power under Article 229,
We
Your
are not
Lordships.
dismissing on that ground, that we will do on the date when it is heard. So we list it.
Your Lordships, they've been asked,
There is no-
if I may request urgent listing on the 16th, Your Lordships.
The Lord,
My lords, may I mention, my lords, that Karnataka mining matter, my lords.
I'm making an, I
Lord-
have permitted to make a mention.
Madam, we have already passed an order granting you the legal aid. Please
It
go
has
and
been
avail.
disobeyed, my lordship. It has been disobeyed. I am still not being provided, my lordship, since 6th
I
of
I have
April.
already passed the order. You please go and meet the secretary. And have your full temper. Don't misuse your dress. This I'm putting a word of caution. I'm not warning today. I'm only putting a word of caution. Don't terrorize and intimidate the staff. You have requested, I myself have passed the order granting you legal aid.
Yes, my lord.
Please go and avail. With best of the ability, lawyers, we could, at least with whatever I knew, I have granted you. Please go and avail it gracefully.
My lord,
You are a member of the bar. You must respect the institution.
I am definitely respecting the institution.
Now,
my
thank you
lordship,
very much.
but I'm
Go and
Lord-
avail it.
relief,
I
my
request
lordship.
to,
if I have my Lord's
Lordship.
permission to mention,
I must get legal aid, my lordship. So far, I'm not being granted, my lordship.
You please go and get it. I have already passed the order. Now, don't waste my time.
My
Your
lords,
Lordships, I request to mention that can I file 2 or 3 page written submission? I request to seek permission to file 2 or 3 page written submission in an IA in Sabrimala matter.
Sabrimala is going on, you can file it.
Oblige, Your Lordship.
May I
my
please?
lords, with permission, my lords,
Lordship,
may I
a
mention?
review
My lords, I am troubling my lords today.
petition coming up on day after tomorrow, my lord, on 15 pertaining to Kaveri water dispute, my lord. We have moved an application for open hearing, open court hearing, my lord. Lordship may kindly consider. This matter is of some importance. In an MA, my lord, an order was passed. Virtually, my lord, giving direction contrary to the main judgment which was rendered in 2018, my lord. That's why we are making a request for open court hearing.
No, is it a review?
Review, my lord, review. But
See whether it is to be had in open court.
Please.
we have made an application, my lord. It goes beyond the main
No,
judgment.
that, okay.
My lords,
My lords, this is a matter for Wednesday, and it's before Justice Narasimha. Unfortunately, he's not there today. My lords, it is a contempt.
Bench?
Justice Narasimha.
Oh,
My lords,
it's only for today.
my lords, no. My lords, there's a fresh contempt that was filed a week ago. Unfortunately, even the defects have not been able to be listed. It's very important and it's urgent. And we just want it listed on Wednesday.
Urgency, madam.
I beg your pardon?
Contempt, what is the urgency?
My lords, the urgency is this. My lords, may I explain? This is a recruitment matter in which Justice Narasimha himself had passed a very, very strong order in my favor. Now, the seats, it has come to my knowledge, have been filled at such a fast rate that quite soon I will, essentially be non-suited despite.
Don't want anything on merits. Please tell what do you want now?
I just want it listed, my lord, subject to the my colleagues clearing the defects.
Day after, on Wednesday, Justice Narasimha will be here. You can make a mention before your lordship.
But if it's listed, then I can argue it on that day, my lords.
We will see what can be done.
With the
My lords,
lordships, can,
I'd be grateful. I'd
Lordship,
be grateful, my
if
lord.
I have my Lord's
may I mention a fresh matter?
My lords are
Will
allowing,
be preferred by
my
the
lords
state.
are allowing it.
We have not allowed or disallowed both.
All right. Okay.
Lordship,
lords, may I?
Lordship, the
may I be
SLP
permitted to
preferred by the
mention
state
Karnataka
yesterday,
mining matter,
Lordship,
lords?
against the grant of anticipatory bail, Lordship. There's some urgency, Lordship, in the matter. Lordship, I'm praying that if Lordships could grant of anticipatory bail, the state has come, Lordship. The state has come by, it's been passed by court, Lordship, according to us, without territorial jurisdiction at all, Lordship. Lordship, we are only praying that Lordship may hear it on Wednesday.
We will examine. We will
Please, my lords, may I mention?
Obliged.
please? My lords, the Karnataka mining matter, my lords, Samaj Parivartan, my lords,
My
we
lords,
had
I wish to
mentioned it in
mention the same.
January. My lords, there are,
Wait for the turn. Every matter is important.
my lords, may I only pray for some date that may be.
We can't promise anything. You know it, question bench is going on. After that, we will see what is to be done.
Mr. Speaker, Lord's permission to mention an urgent oil and gas.
Obliged.
What has happened in Bihar is, my lord, the Municipal Corporation Act has been amended to actually disempower, my lord, the mayor from choosing his empowered committee.
So what?
I challenged it, my lord, that was there was no interim order.
Challenge before the High Court first. Very good.
That order was appealed before your lordship. I have taken out
High Court has, why High Court has adjourned for Monday, therefore Supreme Court. Why it have listed on Friday, therefore Supreme Court. Only notice have been issued, everything is being checked.
One more line, my lord, I listed that, my lord.
Save the jurisdiction of this court for important matters.
I'll just say one more line. They have directed that the empowered committees be appointed between 15th and 20th, and that's what.
Whatever they have done,
Lordship, my lord.
the High Court must have applied its mind. We are not sitting here like every day, keep on monitoring on with the radar what's happening there.
Directed, my lord. This is a direction of the government.
Thank you very much, thank you. No,
Lords, if I have my permission to mention an urgent oil and gas tender matter, my lords, in this case, the financial bid is already opened, my lords, and the respondent may grant the letter of award any moment, my lords. Oil and gas tender matter, my lords. The financial bid is already opened, my lords. The letter of award may be granted any time. I'm requesting urgent listing, my lords.
what's the urgency in it? If you
My lords,
decide, we will come.
My lords, the bid has already, my lords, the bid has already opened, my lords.
All right, it's all right. All early hearings are rejected. Now start.
With your lordship's permission.
Wasting time. We have already told you within 2 days matter will be listed. What is the great hurry? Thank you. Thank you very much. Item 11. Let it be remain a difficulty, but you can't do anything.
With your lordship's permission, may I mention a matter? My lords, it's a leave granted matter. My lords may give a fixed date. The respondent number 1 is 80 years old and suffers from several.
We will see what is to be done. No promise. Thank you.
My lord, the other.
Item 11.
In item 11, I'm requesting a short pass over, my lords.
What is password issue notice? I'll be issue notice.
Grateful, my lords.
Item 12.
Application.
Please wait. Milords, we have sought declaration of section 2, 3, 4 and 8A of the Dowry Prohibition Act, section 2 and 3 of Protection of Women from the Domestic Violence Act, section 498A of IPC, and section 12(1)(c) of Hindu Marriage Act as.
The only mistake committed is that last time some exemplary course should have been imposed.
Milords, may I say that? Milords, may I say that? Milords, the decision has not been made on merits. There was no effective hearing in that matter. Milords, under Article 2 of International
How
Covenant.
the office is entertaining the registry? When the matter has been dismissed already.
Milords, it's an illegitimate dismissal. It is in violation of Article 1 and.
Dismissal?
Milords.
Be then honorable.
No, Milords, there are no, it's by a non-speaking order.
And you are the same petitioner.
But Milords, it was by a non-speaking order. Justice has not been done, Milords. Milords, people have a right to justice and Article 2 is violated. Milords, Article 2 of International Covenant on International Civil and.
The petitioner had earlier filed a petition civil number 68/2025 seeking identical relief. A coordinate bench headed by the then Honorable Chief Justice dismissed that petition on 3rd February 2025. A coordinate bench, a coordinate bench of this court dismissed that petition on 3rd February 2025. The instant petition from a perpetually in public interest has been filed, claiming that the earlier petition was dismissed by a non-speaking order. We find the argument totally frivolous and uncalled for. While dismissing the petition, the petitioner is cautioned in case he indulge in filing such kind of petition in future, there shall be exemplary costs imposed on.
My lords, may I mention? My lords, may I also
Don't
mention?
waste our time, please.
People's rights have been.
Next item.
Yeah. Now, my lords, here there are two cases on your lordship's cause list today. My lords, one is serial number 13 and the other is serial number 49. Now, sorry, I'll just explain it to you, my lords. As far as 49 is concerned, it's a writ petition in which your lordships have already issued notice, 49. Now, on that, at midnight or something, we have been served with a reply.
We have filed a status report.
All right, I haven't even seen it.
It's a status report which the high-powered committee has filed, my lords, in response to the writ petition which they have filed, item 49. That unfortunately could not be filed earlier. We filed it yesterday night. So that's not on record.
You have filed your reply to them.
I'm appearing for the high-powered committee. So
But you have filed reply to them.
a status report because it's not adversarial according to us.
That's right.
Yes,
That's
we
not
have filed a status report dealing with all the submissions which they have made in the writ petition.
Yes, so that is that has come at very late at night, so we haven't had a chance to study it. So I am just suggesting to the court that as far as serial number 49, on which your lordships have issued notice and on which they say that they have submitted, your lordship may call out the matter after 2 weeks is my request, and thereafter, my lord, we'll respond. Now on that. Yes, on that aspect, I should also tell the court, I will have a note which I will.
Counter affidavit is in writ petition
Not a counter, my lord.
It's a status report in writ petition in 1228 of 2025.
1228. That's a separate petition.
Why is it 20?
Now, may I also make a suggestion with regard to serial number 13 on the court. Now, 13 is an MA, where again I have some suggestions, and there appear to be certain factual errors which have occurred in the order. So, in the original order. So, on that I have a note which I will share with my learned friends, because certain historical facts, we don't want those historical facts, if they are inaccurate, to remain in the court's order. So, I am just suggesting to the court, since your lordship is putting forth.
Adjudicated any historical.
No, you're right. Absolutely right. But
That some passing reference.
that's right. So I'll just broadly tell you what is. Sorry. Yes. Number 13, I have a note which has what your lordships have recorded and what our suggestions is. If I may be permitted to just give an advance copy to them.
You can give an advance copy.
I'll give them an advance copy.
Also,
Because we don't want an inaccurate reflection here, because we found that some things may not be supported by the pleading.
Tentatively, we are not proposing and we might not be inclined to make any structural change in the arrangement.
Yeah.
Yeah,
there'll be some small suggestions, yes. But the factual errors can go. So on that, Manoj, may I request that matter also to come along with whatever date. Both the cases can come together.
Item 49.
May I point, as a high-powered committee appointed by this Honorable Court, just we want to go by whatever the direction this Honorable Court issues in this particular matter, we want to go according to the direction of this Honorable Court. We do not want to take any adversarial stand in the particular matter, number one. Number two, if they, yes,
As such, because
yes.
basically, idea was that some development must take place there in and around
Correct.
such historical temples.
Yes. Number two, whatever the facts or suggestions he wants to give it, he can give it on facts. We will place it before the Honorable Court for the consideration.
Going into the pockets of some families only.
Yes.
There was no such thing, Manoj. There was no such thing. Anyway, we'll satisfy your lordship. But on both, I will submit a note right away. I'll just share the note on both aspects, and then your lordships can call it out after 2 weeks. Is my request.
Item 49 will it is stated by Mr. Shan Thakur and Senior Counsel presenting the high-powered what is it called? High-powered management committee.
High-powered committee.
High-powered committee. Management committee. That counter affidavit was filed, has already been filed.
He says status report.
It's a status report according.
A status report has been filed. The same is not on record. Registry directed to tag the same with the paper book. A copy there will be supplied to the counsel for the petitioner. Post this matter on so and so date after 2 weeks.
But it's my response within 1 week to the status.
The response to the status report, if any, may be filed within 1 week. Then item 13 may issue notice. Then transfer assistant counsel and Mr. Nataraj, you are for the state.
No, I am for the High Powered Committee along with Mr. Sharan Thakur. Both of us were there.
Say, so Sri Nataraj from PSC and Sri Sharan Thakur and Senior Counsel representing the High Powered Management Committee. Or the assistant counsel and Richard Agwal, they seek and granted 2 weeks time to file their reply to the MA. Post both this and this item 13 and 49 both in so date.
I'm so. There is some date being indicated.
We'll list a date. We'll give a date because
I'm great.
I have to see about that.
Very well. There's just 1 or 2 dates which I will just request the court master not to give. Other than that, everything is fine. I'm grateful. I'll share the note.
If I may give over the physical copies because they have physical copies of the SPINI file, but physical copies have the color photograph. If I may hand that over of our status report because they're all the color photographs of that and the e-copy doesn't.
Find it.
We'll find it physically.
I'm grateful, man.
Grateful.
Yes, Your Honor. The matter kindly be tagged with the ongoing cluster.
There are other matters pending on this issue.
Yes.
Issue notice. Return.
Obliged, sir.
Is there any date in those matters? Is there any date in other cases?
Yes, I think it is listed on 20th. I don't confirm.
Anyway, 13. Issue notice returnable on 13 May 2026. Tag will soon.
My lord,
Are you accepting notice?
on behalf of State of Rajasthan, ma'am.
For State of Rajasthan?
Very well, ma'am.
Accept notice on behalf of State of Rajasthan. Let the soft copy as well as hard copy of the written on the road to Land State Council. The counter affidavit can be filed.
Very well, ma'am.
Preferably before the next date of hearing, 13th May.
Very well. Deeply obliged, ma'am.
Item 15.
Lordship, this matter pertains to 2 major issues. First is regarding enforceability of pre-primary education, which is not mandatory till date, sir. And second is regarding implementation of.
Would like to know.
Lordship. Second is regarding implementation of Right to Education Act and National Education Policy 2020.
We are issuing notice, sir. We are issuing. We would like to examine. Issue notice.
Thank you. Highly obliged.
My lord, I am seeking short passover, my lord. I am seeking short passover, my lord. My lord, Mr. Nachiketa Joshi is appearing, senior advocate. Nachiketa Joshi, senior advocate is appearing, my lord.
Pass it.
I'm seeking a short passover. Short passover, the council has to approve.
Where is this now in this matter?
He's on his legs to
Don't file this kind of petitions. You have been doing a good job.
Yes.
And we have appreciated, we have done whatever we could do. But as far as this is concerned, the parliamentary prerogative and it is already being taken up.
Very short.
Can I submit, Your Lordship, with permission? Can I submit, Your Lordship? Lordship, connected matter is already notice issued and pending for court number 4 in writ petition number 1092 of 25, Lordship. Court number 4 it is pending right now. Same Dr. Jaya Thakur and all, Your Lordship. It can be both can be heard together, Your Lordship.
No. This court will now enforce the provision which is under Parliament is already seized of the matter there, and it's every day it is being reported. Today is also
The same issue, notice already issued, one court is hearing, Your Lordship. Both can be heard together. Otherwise, Lordship, you can call back that matter to hear and can be heard together. Notice issued, same thing, Your Lordship.
No, which petition are you referring to?
There is another petition in court. It can be sent to that court or call back to your Lordship.
Parliament is
I will address on that issue, Your Lordship. I will come and address on that issue. Otherwise, Your Lordship, pass or will come and petition number 1092 to 2025, Your Lordship.
This Jaya Thakur was withdrawn.
You want to help this see, you go to the yeah. The case is not like this. You love total pressure. Stay to be lost. Those two negligence. You will think you deliberately without schools.
Page 1 2025 along with this petition. List once to do.
Greatly obliged.
Your Lordship, arguing counsel is through VC. Arguing counsel is through VC, item 18.
May I please, Your Lordship? May I please, Your Lordship?
Yes, please.
Am I audible, my lord? Am I audible, my lord?
Yes, please. We can hear you. You are audible.
My lord, this matter raises a substantial question of law, in a sense that a person who is occupying a office of the council member in the Chakma Autonomous District Council simultaneously is occupying the post of office of the member of Legislative Assembly in the state of Mizoram. We challenge it. That amendment which was been brought in the year 2003 is per se manifestly arbitrary. The Honorable High Court said that we cannot read into the statute and there is no corollary provision in the 6th schedule or under Article 190 and 191. So this matter is not made out. Per se, I say that this, Your Lordship has held in Pumilaik's case in Mizoram, that the 6th schedule is a constitution, is a part of the constitution. It cannot be treated as a constitution within the constitution. So this judgment per se is illegal. Let me demonstrate here, Your Lordship. Kindly come to the additional document which has been filed at page 17.
Yes.
Your Lordship will find that page 17, vacation of seats. This was prior to the amendment. Kindly see subsection 1 of 11. My lord is there? Page 17.
Probably the only argument he should have raised before the High Court was
My
that
lord.
it's a case of complete, or maybe, ultimately whether it was made out or not, that was subject matter of argument. But the only argument possibly you could raise was that in the case of Lai district autonomic, this council,
Autonomous Council.
there is a
There-
express bar in holding the dual position.
My
But in
lord.
the case of Chakma council, there is an exemption. Therefore, this classification is not based upon any intelligible criteria. You are
My lord,
argument of holding the office of profit fails because division bench holds against you. That
My lord,
argument was earlier rejected. Now
your
your
lordship,
are based upon Article 101 and 190. Again, High Court's view is correct, but the other argument unfortunately never raised.
my lord, your lordship will appreciate that as far as the office of profit is there, I have conceded that I am not arguing in that office of profit. Kindly come to my kindly come to the SLP.
Just wait. From the impugned judgment of the High Court, it seems that there is a bar on dual membership in the case of Lai Autonomous District Council members, but no such bar has been prescribed for Chakma and Mara.
Only that the earlier bar had the bar
The bar at the express bar in respect of these two district councils has been to notice.
Obliged.
So this is a very important petition. "19, my lord, is a very important petition for the farmers of this country. There are two problems as a result of which, my lord, more than 10,000 farmers every year are committing suicides. One problem is that the MSP that is being fixed by the government is below the actual cost price, which is called C2. Of course, Swaminathan Commission said C2 plus 50%. That was the recommendation, that the MSP should be C2 plus 50%. But here, the MSP that is being fixed is below even C2, forget 50%. Secondly, the procurement of most crops, even at the MSP fixed by the government, is not taking place. Only for wheat and rice, it is significant, is about 35% or so of wheat and rice is being procured by the government at MSP. But for the rest of the crops, it is sometimes 2%, 5%, 10%, etc. So the farmers are in acute distress in this country as a result of this situation, this twin hammering, my lord, as I call it. Firstly, the
lot of mathematical formulas that you are.
Yes.
If these formulas are applied, probably they will start disowning the responsibility of MSP. That is one. But what I'm visualizing,
I'm not even campaigning for, I'm not asking for actual cost plus 50%. I'm not saying that. The actual cost is called C2, which includes all the costs. And that, if you take the weighted average cost of production of a particular crop, let's say, my lord, wheat, take the weighted average cost in the country, that includes all the costs. That is,
Difficulty will arise only in respect of the cost of land and capital.
yes. But that the government itself calculates. In fact, my lord, if your lordship sees, there is a
But because
chart.
of that, will it not vary from now state to state, and even it can vary even from district to district?
So the government and the government's own institutions the government's own these calculations are made. These calculations are made by the government itself, and that this is the weighted average. I'm not saying that in some place where the cost is very high, they should pay that cost. Not at all. What I'm saying is government's own calculation of weighted average cost in the whole country, which is called C2 for the whole country, at least that much should be paid.
So Bhushan, you are almost asking us to rewrite the economic policy.
No, no, it's not.
You are going to the extent of saying that because there is free ration made available
Yes.
on the basis of procurement of rice and wheat,
Yes.
our opportunity of getting higher prices on the free market for these commodities is being destroyed.
Yes.
So do away with the free ration, give them direct benefit transfer.
Not at all, not at all.
No, this is a part of your pleading.
No, that's not, Lord. I have been misunderstood then.
No, your pleading is there. You know,
Maybe, Lord, my junior had drafted it.
So
maybe,
you may say
not
that I am not
exactly.
pressing that portion of the.
No, what I am saying is this. It is absolutely fine for the government to give ration virtually free. Perfectly fine. It is required in this country.
Yeah,
but, my lord, that should not mean that the effect on the farmers is such that they do not even get their cost, as a result of which, my lord, they are committing suicides. So therefore, and I am not saying that you give those farmers in those states where the cost is high. I am not saying that.
That at least this way of calculation.
Yes.
At least somebody should have pointed out to the government, some stakeholders should have been first pointed out that, look here, we should do like this.
No, government itself has done it. See page 394. See page 394. This is the government's own Economic Statistics and Evaluation Division of the Department of Agriculture and Family Welfare. 394, my lord, of the petition. Soya bean. This is one example. Now, if your lordship sees everything is there, cost of cultivation, A1, A2, etc., 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 and then it comes to C2. Now, C2 is the final cost, which includes everything, including the cost of family, imputed cost of family labor plus cost of different. I am deeply obliged, Lord. This is a very important petition. I know, Lord, I don't want a situation where people who do inefficient farming or in states where the cost of production is high, that they should also be paid their cost. I am not saying that. I am saying take the weighted average cost of the whole country weighted average cost of the whole country, at least pay them their cost.
One is, second is, again, some issue will have to be determined. You can't have probably a uniform policy for all sizes of farmers. There are big landowners who have big chunk of land.
You can have a policy where you say, don't procure from those farmers who are large farmers. You can say that. So there are two prayers, my lord. One is procurement, that at least procure on that MSP. You are not even procuring 5%, 10% you are procuring. And number two, my lord, fix an MSP which at least takes care of their actual cost, weighted average cost. That's all. I am obliged.
Rosen, item 20, the main set of cases is coming up on the 13th of May 2026. Now, there's just one or two dimensions that we want to just project over here, if your lordships considers it appropriate. I have moved an application for impleadment of just one state, state of Rajasthan, and because that's where primary work of the petitioner has taken place. And the second is just, we are requesting also notice on interim relief. Let me just explain it before we get down to it. I have handed in a note, which your lordships will just see.
Interim relief maybe, but in any case, we have issued notice.
I'm grateful, but I'll just tell you what the interim relief is about, so that you needn't even turn to it. What is happening is that as a consequence, we don't want a stay of any impugned provision, etc. What is happening, if your lordship goes to the third page, which folds out, is that because of the masking of data and individual data sets, work which is actually going on in the field and work which can be done on the field and on the ground, because it's available, the information is available and it is linked to individuals, may be impaired. So the interim relief which we are, if your lordship is pleased to issue notice, is only that don't please delete data, because that deletion or masking of data will cause problems. Now, my lords, we've just given 3 illustrations. May I just take you to that last page of the note which is handed in? Please just have a look at that. Please just see this. 3,729 pensions were abruptly stopped in the Bhim block. Around 1,000 living persons were declared as dead and without notice. This is, my lords, pertaining to the year 2015-16. We've given an example, a separate example for 16-17 and 21-22. Now, MKSS volunteers obtained the stopped pension list under the RTI disclosure mechanism, containing names, ages, addresses, pension type, and reasons for cancellation. Thereafter, we engaged in a door-to-door verification of the beneficiaries, which revealed that 400 of the so-called dead persons were in fact alive. MKSS obtained the itemized stopped pension list containing names, ages, addresses, pension type, and cancellation details. That named list enabled verification. Now, as a result of this, my lords, the verification and restoration was carried out. Now, this was only possible because those individual names were available and door-to-door verification could take place. This may be impaired. Now, see the second example. Siphoning, this was an example of siphoning of grain from PDS in Thana, Bhilwara. Ration dealers were under-delivering the grain. However, official records spoke otherwise. MKSS volunteers obtained delivery information from the Jan Suchna portal, which includes, and then there is a bunch of information which was there, which was individually available. Now, please go to the next column. The information was projected on a screen during village gatherings, which enabled verification of official records with individuals' lived experiences. This collective verification revealed that over 5,300 kg of wheat had been siphoned off by the ration dealers, etc. Now, this exercise can be done house to house, door to door, on the basis of that information, which is presently being put up on the Jan portal. So it's presently available on the portal. We are apprehending, if your lordship sees the third example, which is securing relief for silicosis victims. The compensation for silicosis patients was delayed for years, leaving several of them in despair. With the efforts of civil society organizations, the victim level data was disclosed through the Rajasthan Silicosis portal containing the identifying information, application status, reasons for delay, and officials responsible. MKSS volunteers use this information to pursue individual claims with concerned officials to facilitate expeditious release of compensation. Now, the problem is that this is how compensation was actually revealed. But if this information is taken off or masked, so information is up there just now because this act, the provisions have come. But the apprehension is because in certain states that was shown to me as well, the masking has started. So interim relief, if your lordship considers it appropriate, may be that please, whatever information is available just now on the portal, don't delete it until or don't make it unavailable.
Even if it is, of course, we'll issue notice. We are issuing notice because already matters are pending. This information in any case can't be destroyed. This information will
is so
beneficial gathered.
Yes. It's so beneficial, and it's only with respect to these public, where there is some government subsidy or where there is government help which is there, but it is not reaching, it is siphoned off, etc. So this petitioner before your lordship is a voluntary organization which has done huge work on the ground. So therefore, I'm requesting also, my lords, on the, I've just handed in an interim application. Notice may be issued on that as well. We'll file it.
Okay. Date is no matters. 13th May.
They should take the application and reports.
Yeah.
Notification in May also. Okay. This one.
Well, state of Rajasthan impleement may be allowed.
Oh, that is. This one and this one is allowed. State of Rajasthan through the department is one to include. Notice issue to the newly added respondent also returnable on schedule.
I'm grateful. Your lordship has issued notice on that.
Yeah,
I'm very good. Okay. Huh?
May it please, my lords. In the Bar Council, my lords, my lords wanted to empower the women, but some are trying to misread that directive of your lordships virtually to weaken them.
But is there any order passed by the empowered
High Power Committee, my lords?
Page 45.
Yes, my lords. My lords could see. That's at page number 41.
No, just India's committee.
Yes, my lords. At page 41. Kindly come to page 47 minutes, where the directions, in the light of your lordship's direction earlier given, the committee has formulated certain policy.
Para 20.
Indeed, well, it's para 20. What's material is clause D in that para 20. The rest talks about various nuances of that one, if more women contested, fewer women contested, or no women contested. What's relevant for the purpose as far as Andhra Pradesh and Telangana are concerned, millets, many women have contested. In both cases, more than 30. In one instance, 55. In one instance, one woman got elected on her own strength. The remaining, they have contested. They have got fewer votes comparatively. My lords, may kindly see millets D. If there are more than 5 women candidates, then counting shall be done in the regular normal manner, except that eliminated women candidate would be placed in a separate list category.
D. If there are more than 5 candidates.
Yes, millets, para D. If there are more than 5 women candidates, then counting shall be done in the regular normal manner, except that eliminated women candidates would be placed in a separate list category or in the reverse order of elimination. That is, the last eliminated women candidate would be placed at serial number 1 and second last eliminated women candidate at serial number 2 and so on. Counting would continue till the requisite number of candidates after deducting the number of women candidates to be elected to the extent of 20% seats reserved for them or declared elected. In case any women candidates are elected in the normal course, the regular and normal process of election would be extended further by adding such a number of women candidates to the list of candidates to be elected in the normal course. The only grievance that we could ventilate with your lordships vis-a-vis this and also Bar Council amended Rule 3 is that, my lords, my lords intended that there should be sufficient representation for the women. And your lordships have felt that 30% should be there. And my lords have also felt that many women will feel shy of just contesting. In that event, your lordships have said if somebody contested, 20% you draw from them and 10% you can co-opt. And now, millets, on the converse, what has happened, many women have contested and they have come very close sometimes or otherwise. In that case, millets, the only prayer that could be is this, millets, that from among the list as has been indicated, let all 30% be selected. Otherwise, millets, what's been indicated in Rule 3 is that, millets, all the bar associations across the state will recommend names. From that, they choose twice the number of candidates, that's 4 candidates. It's a mayhem.
Let us see what Justice Dulia is saying. Right?
Yes, this is what their lordship, the committee has said, millets. And my lord's order could be seen, which has been explicit. That could be seen, Miller's order dated 8/12/2025 at page 29. That's the fountain for this provision.
No, but this paragraph only deals with the situation where Justice Dulia has said that if there are more than 5 candidates.
Yes.
And out of them, say, let us say 2 women candidates get votes more than even male candidates. Then it is like in the reservation, let us say service jurisprudence has been applied.
Yes.
If you are a reserve category candidate and you are higher in merit than the open category, then you are to be treated as open category. That is what the same principle. That if the women candidates get votes more than the male candidates, they will be adjusted in the general category and there will be a separate list of.
That's not been applied.
All the women got less than all the men.
Yes.
Number of votes.
Yes, Telangana.
Telangana. In Andhra, they got.
I'm only supporting you for Telangana. I'm the guy who got the most number of votes.
I know, my friend.
Yeah.
Yes. 30. 30 means High Court direction, Supreme Court.
That's correct. Your lordship's order, in fact, would have bound Justice Dulia's committee.
That is what Justice Dulia has indicated in
Correct.
paragraph 2, page 42.
Correct. So the reason why we are here.
What actually the applicants went there, were for separate ballots.
That's separate ballot. That's anyway not an issue.
Dulia explains that it's a single transferable vote.
Absolutely.
Separate ballot will become cumbersome. Keep it in the same ballot, but the indication of gender should be there.
Exactly.
So far as the women candidate.
So if I may,
as far as
they also gave a very illustrative example of how you are going to count it.
may I just clarify one small thing? Because I am the person who got the number 1 most number votes in Telangana. Man, all the men got, because of the numbers, more votes than the women. But I'm supporting the claim of the women candidates who stood and came 6th and 7th because 30%.
Not endangered.
No, not because of that. I think the fairness demands.
Fairness demands
that where 52 of my bar members have come and taken part in the elections, and there are substantial number of them, and 7 have to be selected. Now, because of your lordship's order, only 5 can come through elections and 2 by way of co-option. It was supposed to be a one-off, and that happened because of the submission made on behalf of
Gopal.
Yes.
When we passed this order,
yes,
we had a pan-India view in mind.
Correct.
Yes, exactly. That's at page 30. My lords could see your lordship's order.
It's very encouraging.
Yes.
You were not there. It was more a concessional order, so to say.
Well, it's now what happens in this case?
Understand the
Yes.
aspirations are very high.
The unintended consequence of this is that, Millets, those who contest, who took the trouble, now they've been marginalized. Those who don't,
Democratic process.
yes,
Anything else?
yes,
The election is democratic.
only in the absence of candidates,
We have to
that co-option should be there.
democratic potential.
Yes.
Free exercise.
Correct. That's all.
But nonetheless, election process already started, and
No, so
It's only,
earlier order we have.
No, so in fact, your lordship's
That's not-
order was in the light of the Bar Council of India telling you that 4 states had notified. Unfortunately, to not pointed out to
was
you
not.
that Telangana, which is one of those states, had not been notified.
both states, Andhra and
Subsequently,
Telangana.
You modified it. But when you lordships modified it, it was still not brought to your notice that you have this many candidates. Now what has happened, the Bar Council of India, and let me tell you candidly, this has been a problem even earlier. The Bar Council of India comes out with rules in February saying we are doing a one-off co-option. We will do the co-option, Bar Council of India. And they will co-opt for my association 2 people after consulting with bar associations of the
1,000 bar associations. And it opens a Pandora's box of having many candidates contesting why only a few have been preferred.
Mr. Gopal.
Yes.
That it's a kind of an understanding or a uncontested commitment in that process that we persuaded Bar Council of India, 20% by election,
Correct.
10% by co-option.
Correct.
Now that rule this year we will not deviate. Number one. The only issue probably which directly you want to raise and you are yet to point out is that what should be the manner of co-option?
If
May I say,
if we can prevail on your lordships to consider that in those states where there are enough women candidates, please follow the democratic process.
well,
Exactly as
either
Justice
way,
Bharti.
either way,
If they
let me
are,
just put it this
if there
way.
aren't, then obviously your lordships.
Either way, either co-option or directly taken, the men have to make way for them, those 5 + 2, 7 candidates. And they have to be taken instead of going for co-option and going across 1,000 bar associations and they're sending the names and some to be picked up. All others will be up in arms saying that why somebody has been picked up instead of me. Because I say that I have my credentials as good as anybody else. To avoid that one, Millets, if my lords could zero in on the candidates who have contested their sufficient number, based on the rank as has been indicated by the high-powered committee, they could be there.
Again,
Either way, it is the women that have to come.
Can I just say one line? The Advocates Act.
But again, you are not picking up the right point. You probably only want to say that co-option should be from among those who have
Manoj,
contested.
we are trying to persuade you to accept the first one. Otherwise, we'll fall back on the second. But the first one, just give me a minute. Section 3, subsection 2B of the Advocates Act makes it clear that in the case of a state bar council with an electorate exceeding 10,000, 25 members elected in accordance with the system of proportional representation by single transferable vote. Now, because we want to accommodate the women, your lordships in the right spirit said that if we don't have enough candidates, then what do we do? But bringing in by co-option is only in an exceptional situation where you don't have.
When we spoke enough candidate,
Yes.
we understood enough successful candidate, not enough contesting candidate. Let us say you were
Yes.
indicating to us
Yes.
a corpus of contesting candidate.
Yes.
Out of that,
Yes.
maybe more than 20% are contest.
Yes.
But a successful candidate,
Yes.
there may be only 5%.
Yes. Yes.
In this situation,
Yes.
what does
No, but
How
the
do
minute,
the co-option-
the minute your lordships
Then the
have put
co-option will be among the contested candidates.
don't give a carte blanche to the bar.
Millets, what happens otherwise?
Go for those contesting candidates.
Yes,
and from
because
that
they've
pool
proved
of
their
contesting-
credentials.
That's-
Otherwise, what happens, Millets? Somebody who has contested, taking all the pains. Yes, ma'am.
No, maybe, and now I'm getting what fell from the Chief Justice. Allow me the allowance of not being as wise. Well, then, if these contesting candidates, if the permission is given to co-opt from
Among them.
it could accommodate 6 and 7. Ideally, my lords, because there's a one-off situation.
It's more a middle path.
I understand. Ideally, if your lordships could consider the relaxation, but other states will also come to you with the same plea. And your lordship will have to repeat what you've repeated today.
There has to be
Yes.
a uniform criteria on all.
That it has to be. It has to be.
It will create complications.
It has to be, yes.
Now, if possibly it can be one of the fair criteria that suppose there are, let us say on hypothetical basis, that 3 women are to be taken in one state.
In a state, yes.
And 3 who got the highest number of votes have been picked up.
Yes.
And they are there. Now, 2 more are, let us say, to be co-opted. One way is that the bar council, like they have uniformly decided that they will decide that who should be co-opted.
Yes.
The other way can be, you may argue, no, the next 2 are in order of voting, number 4 and 5.
Yes.
They should be co-opted because at least they have some
Yes,
representation
that's
behind
Mr.
them.
Naidu's plea, yes.
Maybe some other transparent criteria can also be there. So let us first request Justice Dhulia to examine this aspect because they have got feedback from all India.
Very well.
Isn't it, Joy?
We have already given our representations as well, minutes.
Only thing, sir.
We will.
That's true. That'll be.
ये पैराग्राफ 2 में दुलिया साहब लिख रहे हैं.
If para D can be taken its logical conclusion and remove cap 20%, that suffices.
Problem is because at para 3, the chairman's statement is that liberty may be given to the bar council to fill up posts by co-opting women in the current election. It's 5 years. So 5 years, whoever they handpick, it could not have been. Yes.
Wish to revisit the
Yes.
pool from which co-option is.
Yes, minutes. Either the contested candidates or lobbying candidates.
And also,
it could be either way.
also
one uses his exertion
yes,
and availability and popularity in the bar
yes,
to contest, but does not make the mark of 20%.
yes.
May be the pool from which the co-option may be considered.
In this
if
one
the contested candidates pool is there, it's an incentive, even for the future, for them to come and do that one.
But I have one second suggestion. One is about the pool. The second is who will do the co-option. Surely I don't know if that was your lordship's understand that you will have the Bar Council of India do this co-option for every state. Candidly, my lord, the problem has been the Bar Council of India. The fact that they handpick committees who run these associations for 15, 16 years.
Out can be, we impress the power of co-option to Justice Dhulia's committee. And we, of course, will have to leave to them, to their wisdom, that what transparent criteria.
They are actually.
No, here is the, come. These are the committees.
Mr. Giri,
Ravi Shankar Jha and Dhuri.
this seems okay.
I don't know.
Let them take a call on it.
Right. In the
Committee takes a decision.
It can.
My own, but
Therefore, whom?
Milord, I am for Bar Council of Telangana.
Bar Council of Telangana.
one suggestion is that this committee may associate, because the Advocate General of each state or the ASG is a nominee who is ex officio a member of that respective Bar Council. Like in the Bar Council of India, it's the AG and the SG. So similarly, when this selection is being made, co-option is being made, the committee may associate the Advocate General. Just a suggestion from me. It's not from any of the clients.
Either way, my lords may authorize the committee to decide on this issue, allow us to represent before them, because we have already made our representations.
Start coming.
Yes.
Therefore, we need to pass this order.
Correct.
Precisely.
very early.
Yes.
So today, because we are not touching merits as such, so we are only asking, requesting Justice Sudhanshu Dhulia's committee to take a view.
Yes, minutes. And please allow us to represent before the committee.
And my suggestion for Advocate General is only that local knowledge of who these people are will.
That suggestion before.
Very well. Very well.
We will ask Justice Dhulia's committee to
Consider.
the different viewpoints and then take.
Yes.
Well, in the meanwhile, there is the elections which have to take place to the executive committee. They have to elect their president, their vice president, and there has to be a member who they will nominate for the Bar Council of India. So it will either be done before or after, as your lordships consider.
A week or 10 days, if things could be put on hold, it can be decided.
It is to be done.
It has to be done when? By when?
My lords, 9 states issue is pending, my lords.
Take time, I think.
It was supposed to be done by January 30. But
It will take time.
it will.
So this court-wide order dated 8th December 2025 for an exercise of powers under Article 142 of the Constitution ensured 30% representation for women candidates in each of the state bar council. Out of these, 10% were to be filled by way of option and 20% by way of election. The operative part of the order to this effect reads as follows, whereas 6 of them. Next paragraph. This court also appointed the high-powered election supervisory committee headed by Justice Sudhanshu Dhulia, former judge of this court, along with 2 members, namely Justice Ravi Shankar Jha, former Chief Justice Punjab and Haryana High Court, and Mr. V. Green, and senior advocate from Supreme Court of India. The state election committees were also constituted. Next, at the outset, we acknowledge the commendable European task which the high-powered election supervisory committee has been performing since the date of its constitution. In that process, the supervisory committee has passed a self-speaking order dated 9th February 2026. With a view to clarify as to how the direction issued by this court read 20% by election and 10% by auction for women representation, is to be given effect. In this regard, the supervisory committee has clarified as follows, para 20, page 47 and 48. ABCD.
We need more.
Next paragraph.
Can it be passed over?
We are informed that meanwhile, the Bar Council of India has issued a circular that the selection of candidates for 10% co-option shall be made by the Bar Council of
Rules. Rules. They have issued rules on 18th February 2026.
Inserted a rule which interiorly provides that the selection of candidates for 10% co-option shall be made by the Bar Council of India.
At page 55.
Next paragraph. The lack of clarity in the order of this court as to what will be the mode and manner of 10% co-option is the essential cause of action giving rise to the present proceedings. Next slide. It is thus before us that in states like Telangana, more than 5 candidates, women candidates.
Well, it's both Andhra Pradesh and Telangana. Both Andhra Pradesh and Telangana. The first matter is in fact from Andhra Pradesh. Both are identically placed.
In various states like Telangana, Andhra Pradesh and Telangana, more than 5 women candidates contested the election, and some of them have been elected against the open seats
In Andhra Pradesh.
from having secured votes more than their male counterparts.
In one candidate.
One candidate in Andhra, not in Telangana. Just want to clarify.
And there are instances, as a group, there are instances where women candidates have succeeded, have won the election, securing vote more than their male counterparts. As open candidate. The on this premise, it is urged, number one, yeah, ABC probably. A, the co-option should be from amongst the contesting women candidates. Who have secured the highest votes, though they could not be elected. Or the discussion of co-option should be left to the state bar councils. Or such co-option should be allowed to be made by the Bar Council of India. ABCD T. The exercise of co-option be allowed to be done by the state election committees. That's what. These are all suggestions. Each option has its own merits and demerits. It seems to us that since the supervisory committee headed by Justice Sudhanshu Dhulia is well equipped with the facts and circumstances and have direct assistance from all stakeholders. It seems to us that the supervisory committee headed by Justice Sudhanshu Dhulia is well equipped to take a final call in this regard. It goes without saying that the stakeholders like the petitioners from a state bar councils, from a Bar Council of India, or the contested, the women candidates who are in fray in different states, or other women candidate advocates, might be the direct stakeholders whose assistance to the supervisory committee will be helpful in taking a transparent and objective decision.
Your Lordship.
We therefore dispose of this petition at this stage with a request to Justice Sudhanshu Dhulia, with a request to the Puranam Legal Committee to take a final call, to issue appropriate, to pass an appropriate order with respect to the manner in which the co-option exercise shall take place. Requested above, the Bar Council of India, State Bar Council,
Your Lordship.
and other stakeholders may be heard before passing the.
My suggestion about the Advocate General being associated, Your Lordship could record that, leave it to the committee if they wish to. Because the only problem is who they will associate for each state when they are making the decision regarding cooperation.
That state election committee?
No, the election committee of each state.
That may have been disbanded the moment the election
Once
was
the
over.
elections are completed. I thought because he's a nominated member, he's a member of the.
But as far as petitioners, we have already said that you are the direct stakeholder.
Yeah, well, to be fair, I am an intervener in his.
But I am Millets. I was given liberty Millets so that to go and represent.
Yes.
Your Lordship.
Grateful.
My intervention may be allowed so that I have that. Yeah.
Your
I'm
Lordship.
Grateful Millets.
Your Lordship, we seek the co-opted members to be elected from the minorities. We only seek the co-opted members to be elected from the minorities who are elected from the.
Unless in these matters, another intervention application was filed contending that when it comes to women, there is a provision given. Let it be extended to the minority community also. That's what their contention is.
But that is not the issue in the main judgment. For that, you can always claim. We have no difficulty.
There's no reservation. It's only representation for women.
That can also go to the committee because
The
should not fix.
as to I is disposed of with liberty to the applicants
may be
to
granted.
high power so and so comment.
Well, it expands the scope and it's unwieldy because once that is there, then all other sectors will come into picture. SC/ST reservation should be there. Something else will be there. Because my lords have confined only women should be given sufficient representation. It has never been meant to be a reservation.
It's not unnecessarily this issue because this is only confined to women. You can separately file.
That's my humble submission. Great. Deep.
Yes, item 24. Item 24.
Yes, Lordship. Lordship, the subject land appertains to the major settlement plot number 103 at Lordship, which is a jungle kisam land, Lordship. Kindly see the annexer P1 at page.
Who is the contractor who has financed and funded this PIL?
Yes. No, Lordship, it's not a PIL. It's a Lordship, writ petition.
What else it is? What is your concern, Adurai?
Lordship, my concern is that, Lordship, the land has never been de-reserved, nor converted, nor diverted for the non-forest use.
When this entire construction was being raised, almost 3 crore rupees have been spent. Where were you at that time?
No, Lordship, the construction has been started and they have published the auction for on dated 13th of February 2026 and 23 March 2026, Lordship.
Want to argue before the High Court. No case to entertain this totally petition without dispute.
My lord, prevention is better than cure, my lord. And this petition.
So, Father, your suggestion is very good, but then at this juncture, what?
No, I understand, my lord. This is not possible in this election, my lord. But definitely, my lord, at this. So, my humble request is, my lord, this finger and iris biometric identification, my lord, will not only prevent the bribery, undue influence, personation, duplicate voting, ghost voting, my lord, proxy voting, my lord, but also, my lord.
We are passing a brief reasoned order.
My lord.
Directing the Election Commission there to examine this aspect because it will require a major change in the rules and it might require a huge financial burden also.
Well, under section 23 subclass 4 of the Representation of People Act 1950, ECIA has the plenary power, my lord, to introduce it. Right? What is happening, my lord?
No, power is not the issue.
Yes, ma'am.
Power must be there. Power in any case, anything which is for the fairness of the election, that power should always be traced out. There is no difficulty of power. Power we can also direct them.
My humble request is, my lord, because the only ECI is not party. States have to support and states have to provide some infrastructure. That's why notice is necessary in this matter, my lord. I'm not saying in this five state assemblies, but it will definitely, my lord, next year to 2027 election.
No, if the
and the states has to.
There are two stages. Once the Election Commission of India takes a decision,
my lord,
and if they find that the state are not supporting, then someone comes to us and tell that yes.
My lord, not only the, in fact, finance ministry has to allocate some budget, etc. My lord.
So
that's why.
If the Election Commission of India will demand and the finance ministry creates problem, then only question of our intervention will come.
My lord, this is not adversarial petition, my lord, it will help.
We know that.
So I'm only requesting lots of issue notice, my lord. Not for this, these elections.
See, issuing notice at this juncture is something.
No, I'm not. I'm saying, my lord, at most request, my lord, this is not only for this election. These 5 states, I'm not saying that. Lordship may record that also. This is practically not possible in these elections, my lord. Because there are others. the stakeholders also. That's why notice is necessary in this matter, my lord.
So the issue raised in the instance of extension, filed in public interest. Can have prima facie also like this. Issue raised in respect of in the very nature of things, cannot be given effect, cannot be considered for, cannot be considered for the ensuing elections in some of these states. However, whether such a recourse deserves to be followed before the next parliamentary election and or in future elections of the state legislature, we need to be examined. Issue notice is tenable for that.
Obliged by it. Obliged. Highly obliged.
May please, Lordships. The petitioner herein is the president of Bilaspur, Himachal Pradesh Bar Association, Your Lordships. My Lordships may have page 190 for a moment. Now, I filed my nomination. Elections is on the 20th. I've already filed my nomination. Elections on the 20th, Your Lordships.
Rejected.
No, Lord, my nomination was primarily rejected in spite of there being specific orders by Your Lordships. My Lordships, my page 190 and 189 as far as West Bengal is concerned. Similar issue arose over there, where within a week's time at page 190, Your Lordships had actually directed the Bar Council to actually come up with that amendment that's there. And the notification was issued 1 month later.
They amended it.
They've not amended it. My difficulty is, okay, including, okay, the supervisory committee says that, yes, okay, that has to be done, but okay, there is no approval as of now. My difficulty is, as of now, my tenure ends. Now, neither I can contest for the presidential election is also to be held. I am not the fact that to contest for the Bar Council election, I have not filed my nominations for that.
Advisory committee has permitted you to contest the...
No, it is not. I'm agree by that order. That's the reason I'm before Your Lordships. My Lordships may have page 190 for a moment. In fact, Your Lordship's order of 19th February.
It says the council is to amend the rules.
Please, Lordships.
They have not amended it.
189, a similar situation arose in West Bengal, where in fact they've clarified that. 189, Your Lordships, Annexure P8.
Your nominations were rejected way back on 26th March. Now you are coming.
No, nomination is just on 23rd March.
23rd March, it's been rejected, Your Lordships.
I went to the High Court committee.
As per the procedure, I went to the High Powered Committee, then the Supervisory Committee, Your Lordships. Election is scheduled to be on the 20th. If Your Lordships were to permit me, I can still contest for the elections as of now. And in fact, the Bar Council of India also say...
Rule is to be notified by whom?
Please, Lordships.
This amended rule.
They say that they moved an IA which is pending, Your Lordships. In fact, there's a reference of that. IA number 111-739.
It's mentioned in the order of the supervisory committee.
Yeah, that's at page 9.
It says governed by the 2023 rules. Permitted to participate.
My Lordships may permit me in the meantime, because I have only 7 days left. Now, 20th is the election. Now, 20th of this month is the election. Otherwise, okay, it will be a futile exercise as far as I am concerned, Your Lordship.
So. We can't accept your nomination like this.
My Lordship, the only sole reason for my rejection is because that I hold the post of a president itself. They rely upon up to 2000 rule of 2013, which has been subsequently amended in 2023.
For the next Monday, you can say.
My lordships, if your lordships can have it to say, we'll have it. If it can be listed Friday, your lordships. If it can be, if the matter can be taken up on Wednesday, your lordships.
No, we're not saying.
Constitution bench. My lordships, Friday is fine, your lordships. Otherwise, 20th is the election.
Friday, there is a constitution bench now. That is the problem. Before Monday, there is no event. Monday.
My lordships, Monday would be the elections. My difficulty is that.
Whatever it will be, now it is your fate.
The moral code of,
1927.
please, lordships.
Next Monday, for the stick.
Notice in Dusty.
Item 27, my lord.
My lordships have it top of, one second. If it can be listed top of the board, your lordships.
Monday, you can point out what is top for.
If they permit, at least to say, I can contest the election.
Yes, item 27.
Lord, item 27, it's a classic case where operation is successful, patient is dead. Lord, 16th of March, my lord, I approached the High Court, challenging my rejection of technical bid. 18th of March is, my lord, the bids accepted. That is a finding by the learned single judge. The learned single judge also finds that I was eligible. I have been wrongly excluded. And I am L1 on, my lord, financial bid. However, the contract has been given to now L1 to L3 in a proportion. So the single judge, my lord, the order of single judge is not in challenge before the DB by the Election Commission of India. So the findings have been accepted. Finding is that I am eligible. The learned single judge only says that, all right, now the bus has left the station. Now you can claim damages. You have been wronged by Election Commission of India, but you can claim damages. That is the finding of the learned single judge. But what I humbly submit, but the finding in paragraph 58 and 59.
So close every arrangement.
No, my lord, the only prayer, my lord, I bow down, my lord. The only prayer I'm making is, my lord, the last election is 29th. If my lord may kindly see at page 11, a lot of work is to be done starting, my lord, at 10 days before.
Somebody, one will do.
No, my lord, what I'm praying is, because three parties, my lord, the only humble prayer for my lord's consideration is, three parties have been given this work in share. I could be added as a fourth party. And my lord, a lot of work remains, which is yet to start.
Will not disturb now at this stage. You have been well protected by the. You can have
This suit for damages, my lord, against Election Commission of India, my lord knows the fate. And I have been unfairly excluded. That is a finding.
the view appears to be. This is a possible view that you have only even a small Dadra Nagar Haveli, some kind
Lord,
of.
only one. Lord, Pondicherry has been accepted. Delhi has been accepted. Single judge says Delhi is continue to be UT.
Forget about UT. They have legislative assemblies. Dadra, Nagar Haveli, neither Dam and Diu have legislative assemblies.
But in any case, Election Commission, Lord, that order is not under challenge by the Election Commission.
In fact, we have challenged.
In an appeal by a party, the other party can always put into question a finding.
That's right.
You can't ask for a.
Now, Lord, in the
Definitely
first schedule to the Constitution, Delhi continues to be a UT, and you can't discriminate between one UT and the other.
UT or not a UT. It's a question of a legislative assembly.
The qualification in clause 4B is saying three states. Delhi has been considered to be a state.
Because it has an assembly akin to a
And
state.
Pondicherry has been considered to be a state. And for that reason, learned single judge.
In matters of tender, the interpretation of a clause, first priority and the prerogative of the tendering authority.
That's right.
We interfere only when it is so obnoxious.
That's right.
That
I bow down.
it's our conscience. On the contrary, in this case, we find a logical trend. So why do we interfere?
In fact, even the division bench has not found anything wrong in the detailed interim order passed.
Nobody is saying that you are not competent, but the terms on which they have chosen does not appear to militate against arbitrariness.
It was only, they said states, and the UTs have been considered at par with states.
Great.
Deeply obliged.
Next 28.
May it please your lordships. My lords, the pivotal issue and that's, my lord, a very vital one. Already, my lord, an investigation under PMLA and ECIR is registered. That ECIR is pending. The ED, my lord, thinks that it is necessary for them for attachment of, say, a project like HON'BLE, which has been stayed by your lordships, to seek permission. They come, my lord, and seek permission of your lordships. The application remains pending. The matter rests there. And, my lord, after 5 years, another ED, my lord, over a subject matter which actually arose from a 52,000 rupee dispute, registers another ECIR in Calcutta now, changes the forum jurisdiction, does not discuss that the matters are pending here, goes for a rampage, my lord, search, seizure and attachment of the same property, which your lordships have said no court in India will deal with, and that there is a complete attachment. No other authority will come into the picture. This, my lord, vital issue was raised, whether there could be second ECIR over the same subject matter. One ECIR in Bombay already exists. The, my lord, with utmost respect, the Honorable Single Judge, my lord, notes the contention, but does not deal with it. If your lordships can just have few paragraphs of his judgment. My lord, please turn to, my lord, the contention specifically raised in this regard about second ECIR, noted, but, my lord, no answer. At page 40, my lord.
Paragraph are you pointing out?
Para 40, your lordships would see.
Yes, it was submitted that, we have submitted
Yes,
that.
yes, ma'am. It's been submitted that there can be no second FIR, no fresh investment, or in fact, a prayer before, my lord. Page para 39, your lordship. A page before.
Yes.
The Learned Counsel submitted that although it has been held in Vijay Madan Lal that ECR is not an FIR, yet the principle applicable to FIR, that only the FIR of a commission of a cognizable offence can be registered, and investigation shall be instituted thereon, and no second report of the commission of offence can be
Your
registered.
argument before the High Court was not on the second ECIR, but on a second FIR in respect of the predicate offence.
I must
Because
clarify,
the ECIR referred to an predicate offence where a closure report had been filed.
Correct. No, that's one of
was rebutted by the High Court by saying, apart from that, referred to FIR, there are no less than 58 FIRs.
Correct, man.
Against this company.
Allow me now, my lord, read
Where is the lack of jurisdiction?
para 38 first, my lord. Para 38 at page 90. The counsel for the petitioner has drawn attention of this court. My lord, I have to say two things, and only allow me just about a minute, my lord. The issue today, my lord, is not of, my lord, subsequent FIRs on merging, addition, that also is pending before my lords. Whether, my lord, one ECIR can add other. The question today is, my lord, of two ECIRs over the same subject matter. The first ECIR covers everything, whether the second could be registered. There were, my lord, other issues as well. But, my lord, to this specific issue, allow me to read from para 38, my lord, because this has not been decided. And therefore, my lord, it goes to the root of the matter. 5 orders passed by your lordships, my lord. In Sahara matter, there is every proceeding state in this country. There is a special, my lord, committee appointed earlier, my lord. There was my lord Justice R. Subhash Reddy. Therefore, my lord.
We know that.
Please have a look at para 38 onwards.
Nothing to do with this case.
My lord, para 38, I am not, my lord, saying. I am all on the issue, my lord, whether there could be 2 ED investigations over the same subject matter. Or, my lord, there could be, without disclosing that there is a first ECIR pending, the matter is sub judice before your lordships. ED has filed an IA. If I can read that IA for a moment, my lord. Please turn to, my lord, that IA, which your lordships will see at P2. At P2, my lord, at page 79. Just have a look at P2 at page 79, my lord. This is their IA. The ED is IA before this court. See para 9, my lord, at page 97. Just have a look at that, my lord. It says, pertinent to mention that the Honorable Supreme Court, with the order dated 21/11/2013, had put a caveat on disposal of the assets of the group companies. In this regard, kind attention is drawn to so and so. Now, please turn to paragraph, my lord, 12, at, my lord, page 101. In view of the above, since the matter is sub judice before this Honorable Court, the applicant, which is ED, considers it appropriate to approach this Honorable Court for apprising and seeking permission of this Honorable Court for issuance of provisional attachment order in respect of the properties involved mentioned in the enclosed schedule. The schedule included Ambi Valley property and all other properties. This, my lord, permission is pending since 2017 before my lords. They abandoned their IA. It is listed. It is marked that none appears for them also in one of the dates of hearing. My lord, P9 is that order. But my lord, simultaneously, 2023, they registered another ECIR, and in 24, they have attached the same very property, which is the subject matter before this Honorable Court. If this is not overreach, my lord, it could not be a better case. So the issue today is, my lord, and very unique one, which has to be addressed by your lordship, my lord, one way or the other. Could there be, my lord, two ECIRs over the same subject matter encompassing all, my lord, properties of Sahara Group? There has been one which covers everything. Could there be another? The second is, my lord, adjunct to the issue which is pending. We are arguing, my lord, from the petitioner side, their cases, that, my lord, multiple FIRs cannot be subsumed and merged into one ECIR. That's an issue pending, my lord. I was not arguing on that issue, my lord, before the High Court. The High Court issue was whether there could be two ECIRs. There may be, my lord, several scheduled offences. If they have the power to subsume and merge, they could easily merge with the first criminal complaint which was filed by the SEBI, which is the subject matter of scheduled offence in the first ECIR. So where was the question of registering another? And that too, my lord, all attachments made without reference to all these proceedings which have taken place. Whether, my lord, this amounted to, my lord, selective material being taken into consideration, or, my lord, omission of the vital material, your lordships have lit.
There was no injunction upon ED to attach other properties which are proceeds of.
My lord, there's no dispute about that. I'm not saying that.
So what is the scope of the other proceeding 24?
My lord, your lordships have granted complete.
With regard to the disbursement of the funds and the assets of the company
My lord,
amongst the people,
your lordships,
home buyers in the Ambi Valley.
I'm very grateful, my lord. Please have a look at your order dated, my lord, November 2013, where your lordship said Ambi Valley project estate, 7th February 2018, page 108. Just have a look at that one. Just have a look at the order, my lord. I think I'll bring home that point, page 108, P4. And just see, my lord, the operative portion there. That, my lord, serial number Roman 8 at page 115. 115. As this court is in ceasing of the matter, no other court, the country shall entertain any litigation pertaining to Ambi Valley City. And before that, my lord, Ambi Valley City assets, my lord, completely, my lord, should be attached and ordered accordingly 6/2/2017, page 103. Page 103 for a moment, my lord. Your lordships have directed the attachment of those assets. They're already attached.
These are not Ambi Valley City assets directly. These are assets which, according to ED, were proceeds of crime pursuant to the alleged scheduled offences committed by Ambi Valley and its group companies and its directors. These are assets which were placed, layered in other juristic entities.
Correct, my lords. I am on something else, my lord.
Understand your submission with regard to second
ECR. My lord, allow me just 1 second there so that I can make it good. Ambi Valley City, the ED1, ED number 1 wanted to attach, come to your lordships for permission.
Sir, you would face with your second ECIR argument is Vijay Madanlal Chaudhary, unless clarified, does not put ECIR on par with the first information.
That's right, my lord. I'm saying two investigations. Let me not say ECIR.
Difficulty, what happens
my lord.
Is, so in this situation, we cannot apply the ratios of the Supreme Court with regard to multiple FIRs. They are more administrative actions.
Correct, my lord. That's precisely I'm saying.
rules governing the various units
Please, Your
of
Lordship.
enforcement directorate.
Please, Your Lordship.
That give rise to a legal right on a person who is being inquired into.
My lord, I am.
It is between, let us say, the Mumbai Department of EC with the Kolkata Department of EC.
And both leading to prosecutions.
No prosecution has been launched till now.
My lord, launched in the second case. In Calcutta, launched.
What is a complaint has been filed?
Yes, my lord. That's what I'm saying.
A complaint has been filed?
Yes, my lord. Complaint and people have been arrested.
Arrest is not complaint.
My lord, complaint filed. PC filed.
If complaint is filed,
Yes, my lord.
the Bombay case stands transferred to Calcutta. That's all.
My lord, that's
it subsumes
my lord,
in the Calcutta.
issue of complexity arises. Allow me just
Your difficulty lies there.
just 5 seconds more, my lord.
Unless the
Now your lordship says, my
NYAYA
lord,
comes.
just 5 seconds more, my lord. Have a look at, my lord, my lord, may just allow me, it's a very vital issue. It will govern, my lord, many other cases. So allow,
Now everything is being questioned.
my lord, please have a look at the provisional attachment order passed by the second ED now. At page, just see one line. Allow me, my lord, I'll have satisfaction, not like Alice in Wonder. I wanted to say something. The same MB Valley has been attached by them in 2025.
See there when we are looking for investors' interest, not your interest there.
My lord, everybody's interest is prejudiced. If ED, my lord, if ED takes over everything, even your lordship's orders, it would be, my lord, it's not about me. It's about, my lord, the principle of law. My lord, they can't be above the law. They can't do anything and get away with that. They can't conceal facts before, my lord, every court, every forum, in every order. They do not even make reference to Supreme Court proceedings. Whether they are relevant or not relevant, my lord, is a separate question. But when your lordship say this property is attached, why should, my lord, they go and register a second ECIR to attach that?
Thank you. Thank you. Item 50.
My lord, then I'll make an alternate request, my lord.
No.
Only on alternate request, which is very vital, my lord. There, my lord, all these submissions, what I'm making, let me make it a relevant time because, my lord, there is now a prosecution complaint filed. My lord, make the issues open so that I can raise them, my lord. These are cursory, my lord, glances by the High Court. My lord, I'll not press this SLP with liberty to raise at an appropriate stage. That's all. I'm saying only that. That much your lordships may allow, my lord.
No. Then again, these arguments are there. You will never allow the things to move in the right direction. That is the whole problem in this country.
No, my lord, if I have an issue, I must argue it.
Yes.
I must thrash it, my lord. So give me that much of liberty, my lord.
Item 54 now, please.
Lordship, please. Lords, the joint venture agreement in June 2017 actually describes the shares, man.
The argument before the arbitration now.
The problem is that it's a partition issue. Lordship may just see the petition which has been filed before the High Court also. It very categorically says that the dispute is between inter-se parties. How am I be there in the arbitration? Why should I be there at all?
What precisely you will argue before the arbitration?
But let's see page 34, Mala. Just want to satisfy, Mala. Just see page 33 and 34, Mala. The shares of the parties have been determined. I am entitled only for 62.5% and the original landowners are entitled for 37.5%. 2017, my lord, now the entire development.
Thank you. No case to interfere with the informed voter made out.
This matter can be taken up at 2:30, my lord, together. We'll have a comprehensive hearing at 2:30. Yes. It can be taken up.
All this kind of repetition are maintained.
Lord, I'll answer on all questions if your lordship. If you not, I can answer them now, my lord, or at 2:30. I can answer all questions now or at 2:30.
No, why should we hear it? Where's the question of answer?
No, my lord. Why your lordship hearing the matter? Yes.
Yes, please argue.
Yes. So your lordship may kindly see, my lord, that if your lordship may kindly see, my lord, the first order, page 95, my lord, of this court, my lord.
Have you filed any appeal?
Yes, my lord.
Then go on before the appeal. Today we have got the report.
So that's what I'm saying, Lord. That's what I'm saying. Lord, let there be a comprehensive hearing, my lord, or at, my lord, 2:30, since your lordships are hearing it, my lord. Yeah, I cannot, my lord, ask your lordships to, my lord, apply your mind now and then again, my lord. That's why I said, my lord. At 2:30, if your lordship want, otherwise, my lord.
Every day they become a fashion.
No, my lord, what, see, my lord, if you have a pain over here, my lord, we come to the highest court. We can't go anywhere else.
Their appeal.
No, then I wish to argue it out, my lord, before your lordship passes any order.
Please argue then.
Yes, my lord. So your lordship may kindly see, my lord.
Why should we not look at any document? You have filed the appeal.
The reason is, my lord, I'll give a reason. No, your lordship, my lord, will not get angry at the first instance, my lord. Your lordship may kindly hear me, my lord. So your lordship may see, my lord, the first order is, my lord, passed, effective order is 10/3/2026, my lord. Where your lordship, my lord, said, my lord, kindly have, my lord, page 95.
Please tell us, you have, the judicial officers have not found you to be a valid voter, right? Your names have been excluded. You have gone in appeal. We have constituted the tribunal. Today we have received
Yes,
today we have received the report that tribunals are functioning right from today morning.
What I'm saying is this.
So what you want to argue for?
Because Mr. Naidu said, my lord, that 9th is the freezing date, my lord. I will not be heard after that. If I'm going to be heard today, my lord.
Your appeal is allowed, and if they don't include, then come to us.
So, my lord, are the appeals being heard today, my lord? Is my question, my lord, to the ECI.
Well, you can't blackmail the tribunals like this.
Doing that, my lord, your lordship, first, my lord, I have not even placed my case, my lord. I have not even placed my case, my lord.
You have filed your...
My lord, today, your lordship, my lord, at the first instance sent me, my lord, to Justice Siva Gana. Now, that order, the substratum of that order, my lord, is three-phased. The first is, my lord, those who are having... No, no, I'm explaining.
They have resolved their MOP that has been circulated. Yesterday, they have got all the judges on the appellate tribunal. They have learned how to deal with on the online appeals. That training has been completed. The Chief Justice of the High Court has informed us officially that today they have started hearing the appeal. If you have an urgency in your appeal, go and make out a case.
My lord, we are there, my lord. The only problem is, my lord, I'll be very...
Only because your clients can afford to come via Supreme Court. Therefore, we should ignore the other appeal.
No, I can't, my lord, I argue like this, my lord. Then there's no point, my lord. Then I leave it just like that, my lord. If I'm not allowed to argue also, my lord, then what's the point, my lord?
No question of argument.
My lord, the thing is, my lord, your lordship may kindly say, my lord. My lord, your lordship may kindly say. 9th, Mr. Naidu, my lord, says, my lord, that all the list has frozen. Is the list frozen?
Not the final
My
authority.
lord, he doesn't even place the matters. The election commission doesn't even place the matters before Justice Siva Gana. Your lordship may see the order, what they do. Just pass the order. They don't even place the orders. They don't know what is happening. The ECI doesn't know what is happening. They don't place it before the court. Your lordship
is concerned about them. You go.
So because they are supposed to have all the documents.
Somebody without any basis.
Former Chief Justice of the High Court, the appellate tribunal. Why don't you go and argue your appeal there?
My lord, the reason is, my lord, that the freezing date, they say, is 9. If they make a statement today, my lord, that all appeals are going to be heard, I am not going to come here.
You go there, you argue this.
I am there, my lord, it's not being taken up. There is a practical difficulty, I'm saying, before this court with very folded hands, my lord. There is a practical difficulty. The people are lined up, my lord, the appeals are not being heard, and he says the freezing date is on the 9th. Let the freezing date be extended. That's what I'm saying.
That cannot...
They are nobody to decide it. That will be decided either by the appellate tribunal, or if your appeal is allowed, we will decide.
So, my lord, my only request today is, my lord, with folded hands, my lord, and I'm, my lord, requesting with the greatest humility, my lord, will all the appeals who are there, my lord, will they be decided within a given time frame, or will they come beyond the late? That is our request. An honest voter, my lord, who was there, my lord. And
same answer, that do you want us now through a judicial order, command these, thankfully that these former judges, former chief justices have agreed on our request. You want us now put them under pressure to decide how many appeals?
I don't want. What I say is, my lord, the former Chief Justice, a great respected Chief Justice of, my lord, the Honorable Supreme Court of the High Court, my lord, has given 3, my lord, categorical findings. A, those who are having Aadhaar, those who are having passport will fall into the judgment of this court. So, my lord, all those who come under that category in one, my lord, in one swing, they will, my lord, immediately be allowed.
Oh, that is for the appellate tribunal.
Correct, my lord. Correct.
They have themselves, as we understand from a communique by the Chief Justice of the Calcutta High Court, sat in a conference, worked out the manner in which they are going to dispose of the appeal.
Yes, ma'am.
Now, there is a large number of appeals.
Of course, but there is a practical difficulty.
Today, we are not in a position to say that you dispose of X number of appeals every day.
I don't say that. I don't.
Let us see if the Honorable, the former Chief Justice has passed an order, it is expected that the committee of the tribunals, they will follow the same, or if they
They have
differ,
already
they will give their reasons
We
for
are sharing
differing.
with you, they have already.
Today, in a particular
Yesterday
case,
they had-
ECI chooses. Today, in a particular case, ECI chooses not to place records, or that is to say, not to seriously oppose an application. But there may be cases and cases where ECI feels that they will seriously oppose an application. It has to be left to the ground granular reality of each and every case.
Before the last date of nomination, before the last date of nomination, whenever anybody came, we volunteered. We have never taken on any technicality. We said that today itself we'll request the Honorable Appellate Forum so that that could be disposed of.
Predicament.
And he wants to accuse because we have helped.
If we pass an innocuous order accepting your claim, look at.
No, I don't mind. I don't want my claim to be adjudicated by this court. I'm so sorry, my lord. If that is the idea, my lord, I take everything back. My only prayer and the only prayer is, my lord, great respect, my lord. Please let, my lord, the appellate tribunal, my lord, hear me within a given time frame so that I'm a mapped voter, my lord, with Aadhaar, with passport. Should I come into the same category?
I
want to commit
believe
the same
there are
category.
30 lakh appeals.
Our earlier order can be the same order so far as your clients are concerned, that one of the tribunals will take up your case and dispose it. But to say that it is to be done by tomorrow or day after tomorrow, in your part, there was one particular case where there was a candidate.
He himself represented millets.
Why we gave that specific time frame is because of section 100 of the Representation of People's Act. Unfair denial of participation as a candidate is a ground to cancel an election. But right to vote will pursue until and unless it is a enormous number of electors. Which under section 100 does not fall as one of the grounds for cancelling an election.
And if voters, as my brother has pointed out, where the again borrow the language of the statute, which can materially affect the election.
Yes, material.
What I'm saying
not
is,
mere omission.
Very important thing.
If an idea is given, my lord, no.
Consider this. A number of 10% of the electorate does not vote. And the winning margin is more than 10%. What will happen?
Only academic
election is set at not.
Only academic exercise. But suppose margin is 5%.
Margin is 2%. And 15% of the electorate who are mapped would not vote. There may be, we are not expressing any opinion, but definitely we have to apply our minds on that.
Your lordship's main worry would be, my lord, that those who, your lordship's
We are making a very graded approach.
Of course, my lord.
To ensure
Yes, my lord.
that all the rights,
Yes.
including the fundamental duty of the Election Commission as a constitutional body, are balanced and a fair and impartial exercise is undertaken.
If my lord,
Not to forget, never keep this in your mind that the concern of a vigilant voter whose name perhaps correctly or incorrectly is not in the list is not in our minds.
of course it would be, your lordship's, my lord, are men of wisdom, my lord, great, my lord, learning, my lord. Only one thing, my lord, if an idea is given.
The very creation of appellate tribunal is that idea.
Yes, my lord, I know.
To
It
ensure
has been
that there should be a second.
my lord, it has been a gigantic effort by this court, my lord. This court has leaned over backward, my lord, to ensure that the rights are protected. My lord,
only talking inclusion. There's an objector filing an appeal.
If
An objector filing an appeal
Objector.
in respect of an inclusion in the electoral roll as per the recommendation of the judicial officer. If that is also allowed, then that person has to be removed from the electoral roll.
But today, my lord,
They have
what-
done it. Where is another putting? That's our worry. There is another.
it has been, my lord, quite taxing on this court, my lord, because of the time frame. My lord, I fully appreciate your lordship. My lord has done a
This
great
is
effort by
the-
700, my lord,
It is
judicial.
the judicial officers and now the appellate.
Yes, my lords.
So, my lord,
My lords may
only-
recollect, my lords.
only two
Initially,
submissions,
your
my lord.
lordships were not even inclined to have an appellate tribunal.
Only two submissions.
Saying that one, since the judicial office have been exercising the power granted by your lordship, that should be the one, nobody should sit in appeal. Then my lords have relaxed that one, said that let there be an appellate forum. And these people have their remedies there.
Very vital questions involved, right?
Yes, my lords.
See, we have permitted the constitutional authority with its concern of purity of electoral roll to go into inquisitorial exercise.
Yes, my lords.
If you see the original SIR notice, it talks of the benchmark as 2002 electoral roll.
Yes.
So the SIR that had comments does not touch a person who is in 2002.
Yes, my lords.
But when you flag logical discrepancy, you in fact touch that 2002 electoral roll.
My lords, what we have said is anybody who has been there in that one, they are automatically in.
But then the logic,
Provided, my lords, provided they can put their credentials and track this thing without any discrepancy.
sir,
Yes, my lords, with great respect, I can demonstrate.
2000, if you
Yes, my lords. Yes,
will examine it definitely.
indeed, my lords.
But
Yes.
we can tell you the way we read the 2002, your notification, a 2002 electoral roll is fixed. It is not touched. What is touched is people who are relating them to the 2002 roll, like a son whose father is there. He relates to 2002 roll through what? Through a passport, through any other document. 2002 roll is the benchmark. Why? Last election intensive is that. In the logical discrepancy list, and that is why in your final list that you published, you did not delete them.
Well, let's make absolutely there's no question of any deletion.
Not delete
Every person has to submit a form
No, sir.
where they have to
Not-
establish that it's one and the same person.
Please again examine your.
Yes, ma'am.
petition.
I will.
A
I will examine.
2002 entered voter does not require to give anything.
Your lord.
And that was the submission. You were not present.
He has to give a form
Mr. Naidu,
affirming that he is the same person.
when the Bihar SIR was argued.
Yes.
And we understand Bihar SIR is a facsimile of the SIR that we are dealing today. Because that's a common SIR. The submission was very clear.
The only difference is.
Well, it's the same form, the same method, nothing has been changed.
That is
And
so.
what we have said is that, minutes,
So the submission from ECI was unequivocal.
Yes.
A person in the 2002 electoral roll does not require to give anything.
Millets, he need not prove anything further. Only thing, he is the same person. For that purpose, we have given two columns. The column which reflects 2002 name and the present credentials. If they match, automatically is in. In most of the cases, Millets, unfortunately, they have not taken care to put the correct particulars. They've invited the trouble.
If that is so, please examine the written submissions put in the Bihar SIR
We will.
case.
We will.
It is very clear.
Millets, I take it and I'll just
Not
come back to your
that
lordship.
the entire electorate has to upload documents. No.
Millets, no document is needed provided you are there in 2002. Those who have, yes.
Now you are
Listen, Millets,
amending your
I'll just demonstrate in one
You
case,
are
Millets.
deviating from your original
No,
document.
Millets, what has happened, in 2002, somebody is else there. And they have to replicate whatever was there in that one. And they,
Let's not, you are only trying to say that somebody says today that how have you excluded my name? I am there in the 2002 list. You are saying, sir, if you are there in 2002, you are welcome. But in 2002, the name is XYZ. Today you are claiming XYL.
exactly.
Therefore, the problem is right. XYZ.
That's the only discrepancy. Had they faithfully filled the forms cautiously, that the same person, they wouldn't have been automatic. They would have been allowed. What they have said is, that's my alias name.
A 2002 elector does not fill any form.
Millets, they need 2 minutes. Enumeration form is a mandatory one. Form, all that they have to do is, may I just give the practical ones which we have done, Millets? I'll show them to your lordship, so that my lords could appreciate.
Fill up their names.
Yes.
That is it. No
Exactly. It's a ministerial job of filling up the names correctly. If they have not done that.
That is only an format without any documents. That there you disclose that yes, I am there already in 2002. I am not required to.
I am not required to put in any confirmatory document.
Yes, not necessary at all.
Document is
That
for
name itself is enough. Only thing is, the details should match. There ends the matter.
Now what?
I'll just submit a model forms to your lordships. Kindly consider that.
So
Whether there is any
you are
deviation.
submitting model form to someone who has filled up a form.
Beg your lordship's pardon.
You are submitting model form at least to me who has filled up a form. All right.
No, Millets, but the cases where they have not matched, despite their being there in 2002, once they have made a mistake in presenting the present enumeration form, that flags. Otherwise, it's in.
That is not only the filter used in flagging logical discrepancy. There are multiple filters.
Millets.
There are multiple filters like, let us say I am person A.
Yes, Millets.
Son of person B.
Yes, Millets.
My name and father's name matches. But there is a filter that there is another person by the name of C, whose father name is B, that's the same, and they are born within 6 months. That sort of filters are
That's
there.
what we have called logical discrepancy, Millets. That's what we have called logical discrepancy.
What I am bringing you.
Yes.
When you bring in this logical discrepancy, it actually invokes your constitutional powers of verification, right? That can never be taken away. It is there.
Yes.
And what you rely on, in our understanding, is Section 22 of the Representation of People's Act. That is a suo motu inquiry. Yes. And when you go into suo motu inquiry, Mr. Naidu, you examine Rule 19 to Rule 23 of the Registration of Electoral Rules.
Yes, Millets.
They require a hearing upon notice. In this situation, what happened was there was no hearing given. It was only a verification.
Millets,
after that, we submitted. That is why we are coming to this. Why we wanted the appellate tribunal when there was a constriction at the first instance verification. We need to protect the due process rights.
May I just submit one thing, Millets? Once we have published the list of logical discrepancies, whatever the variations, Millets, and then based on that one, they're informed, then they can as well submit to the ERO their objections or their justification. How in that process, my lords have said, because of the inadequacy of officers, judicial officers have come into picture.
Been done because the volume of logical discrepancies which were marked and the date for the election was so close, and there was a constitutional issue of trust deficit, which we pointed out, between the people given by the state, inadequate, not literate with regard to the...
The whole issue began there when we wanted adequate manpower, trained ones. That has not been provided.
In this situation, we had to evolve a process. The process, however, had certain departures from Rule 1920. Because 1920, when you see an inquiry, it speaks of a notice, the opportunity of hearing and opportunity of presentation of documents, hearing being discretionary on the election officer. We could not give hearing wherever necessary by the judicial officers. So we have to leave this open for the appellate tribunal. And that is why our request to both of you, we cannot hurry this process.
Well, as far as the year was concerned, there were hearings happening. Then judicial officers have come. Kindly see, Millets, the justification of logical discrepancy. To this day, after the scrutiny of judicial officers, 47% is the rejection.
Cannot on the,
Because they've been justified.
not on the end justifying means. We are on the means subjecting themselves to the reasonableness and fairness.
Could my lords recollect, Millets? The whole trouble began when we wanted EROs who have had this quasi-judicial experience. They were not provided. Once we have taken...
Mr. Naidu, it is not a fight between the state and the election commission.
Inadequacy of manpower, Millets, I'm submitting.
It's not a blame game. It's a question of the voter being sandwiched between constitutional entities.
Millets, we have given every provision. We have given every assistance.
When we are fully in agreement with you.
Yes, Millets.
From your point of view, you have put your best foot forward. From the state's point of view, they are circumspect. We have decided that in this situation, to ensure a fair and impartial election, the purpose of the court must be enabling and not a adjudicatory exercise of who is right and who is wrong.
Millets, in the orders also, your lordships have chosen the votes very carefully in a very balanced manner. Never an accusing finger, either side.
The very spirit of court's hands-off approach, and if you see Mohinder Singh Gill,
yes, Millets.
Lokhi Kantro Sen,
yes,
each and every case, the courts have intervened to promote fair election.
Millets, we have had every endeavor.
Or interdict an election.
Yes,
and that is our spirit, which we invoked under Article 140.
Precisely, Millets. Even
deploy officers where there was a trust deficit between the state and the constitutional entity responsible for superintendence of roads, that these judicial officers will undertake a verification. But the volume, because we were not able to give the adequate numbers, the volume at which they had to do, there is always a chance of error. Just consider, Mr. Naidu.
Yes, Millets. Could my lords?
Going through 1,000 documents a day, if our correction or accurate rate is 70%, at least speaking for myself, I will rate the activity excellent.
Excellent.
So this is the pressure at which the judicial officers have worked. And so there will always be a margin of error. And in these situations, again, tested from the principles of reasonableness, due process, we need to have a robust appellate.
Yes, Millets.
We need to have a robust appellate program where both parties.
May I add only one thing, Millets?
And have a continuing right.
Yes.
Somewhere we are getting blinded by the dust and fury of an impending election. But a right to remain on a roll, a right to vote in the country where you are born, is something which is not only constitutional, it's sentimental.
Indeed, Millets.
It is the biggest expression of nationality and patriotism that you are in a participatory process.
Democracy.
To create and elect a democratic government. So this is something which we need to very seriously.
Precisely, Millets. Precisely. We have given statistics, Millets, involving all states that have been subject to SIR. The exclusion or inclusion, we have given the percentage. West Bengal doesn't stand out in any manner. It's been on a par with many other states. And only question is that, Millets, with regard to manpower, my lords have come to our rescue.
We are not bothered about West Bengal standing out or West Bengal.
It's been on a par, Millets. Only question is
being a common theme.
Yes, Millets.
But today, logical discrepancy has not been a category in others. We have examined Bihar and we have found not a single person was flagged on logical.
Millets, Bihar too has exclusions. Not even a single appeal was filed. What's the percentage of Bihar? The table, you see? Take the table.
I move. Maybe I agree with you. How come we missed it? Was there any logical discrepancy? The election control and always manage the problem that are faced. We have 45 deletions. How come you are this side? Next one, okay. 47. Yeah, that's what I'm asking. Give it to the Justice Bakchi's thinking that notice says there are no hearings on logical discrepancy cases, which is not correct. Notices will come, issue, they receive hearings happen before the ERs. The fact that the state of defeated making the petition of Saskia. The council issue when the hearings did not happen for the petition of. But it's not so that there was no hearing it. It is his right that there may be errors. That's why we are also pointing out that there are errors in their decisions. And we will also point out things. The tribunal should therefore not be agreed by such kind of petitioners. That is all that we are saying.
What are those people who have assisted us? What are they called? Are they still there?
Yes, they're still against. They have been given assistance to the judicial officers. Now that the job is over, then they have been deployed in the election building.
My lords, may kindly appreciate one thing, my lords.
Working the appellate tribunal, it's not a competition of
They have an enormous task now.
conflating the electoral roll or deflating the electoral roll.
Neither way, my lords.
Ensuring a fair hearing in inclusion and justifying it.
Absolutely. My lords may have seen when there are strange instances, candidates coming over, we have readily volunteered, gone over there and we have done it. With regard to my lords,
Very right and good spirit that.
yes, my lords. Now it seems there are about 25 to 30 lakh appeals to be decided by them. 34 plus, my lords.
On a very arithmetic computation, each tribunal is having over 1 lakh appeals. If each one is
From day one, my lords, from day one, wherever there is an exclusion or flagging out, we have put them on notice, and micro-observers have assisted the EROs and later the judicial officers, and at arriving at the just conclusion, then the orders were passed. Only the issue came with regard to the inadequacy of EROs. Otherwise, it was a smooth keel.
The question of hearing was not there.
Yes.
So in these situations, we may require an online. Now tell us what we want.
I'm afraid there was hearing before EROs.
My lords, is hearing the West Bengal SIR matter to.
There was.
There's no use of any academic exercise.
So be it.
So we'll see that how the tribunals work and.
Yes, my lords.
Your
Yes,
lordship is hearing the West Bengal SIR matter to.
If
My
I
lords.
give the order passed by Justice Sivagnanda, my lord, your lordship may kindly read.
We
matter
will
two
not
during.
mention any
I-
of them, which should be very clear because it will.
No, the other matter, my lord, your lordship want me to continue the argument with that, my lord, or should I conclude it here and now?
No, here there is no question of we will not enter.
No, I'm not. If an impression is given, my lord, that I want to score a point and come here first, take an order and run away, that's not the point, my lord.
Still half day working.
Yes.
Instead of getting an order in the evening,
Yes.
better you pursue your appeal there.
No, I'm not saying
Make
that.
out a case of urgency before the tribunal.
So if your lordships, my lord, are under the impression that I've come here to get an order from your lordship, run and score the match over others, it's not that, my lord. I come here, my lord, to say that, my lord, till the 5th, the venue, my lord, was not established. There's an
indicated to you.
no so if the ECI comes up and says, my lord, that first, second we did everything, there is a letter by the registrar, my lord, of the High Court saying the venue is not available.
You are more concentrated on.
No, not. I am now on para 9. Then your lordship may see page 103, my lord. They say, my lord, that the judicial officers, my lord, have worked backwards. You see page para 9, my lord, at page 103.
Anybody will try to target the judicial officers. It is not acceptable.
Nobody is targeting anybody.
But once the documents have been scrutinized,
If the documents have not been scrutinized, the High Court Chief Justice says the documents are not scrutinized, there are no reasons given. Kindly see.
It's a wild.
The High Court Chief Justice says that there are no reasons by the judicial officers. Para 9, your lordship's order.
let them pass an order.
So if somebody passes an order saying delete it and without any reasons,
Once the judicial officers have scrutinized the document, there is a
they
presumption.
have to give reasons. They have not given. The High Court Chief Justice says they are not giving any reason. I fear. He says I fear it.
Disrespectful like this.
My lord,
They have done a commendable job.
they have not given any reasons. They have brushed everybody's side is my submission.
They have done it.
They could not have done that. The High Court Chief Justice says at para 9, the issue of alleged non-availability of reasons for rejection of the objection by the adjudicating authority, namely the judicial officers, is also highlighted by the learned Chief Justice.
Let's they've been given an
And this is the
opportunity
what
to file an appeal and to
before
vindicate their
Justice
stand.
in that particular
They've been
matter,
given an
they don't give
opportunity.
the reasons. Just
Let's-
read that order. Read
that-
para 9 with what Justice Sivagnanam says.
Since the petitioners have already.
It is very unfortunate.
Before the appellate tribunal, we are, in our considered view, the rest of the apprehensions expressed in this petition are premature. It goes without saying that if the petitioner's appeal is allowed, the necessary consequences shall follow. If necessary consequences shall follow. The petitioner, if so advised, may therefore approach the appellate tribunal before whom their appeal is listed and make out a case of out of turn hearing. It is explained, we clarified that we have not expressed any opinion on the merits of the case.
That is what they're doing.
Manoj, may I have your
This is very unfair.
It is not unfair.
May I have your
Yes, yes. When you are frustrated, you don't have a point. The only thing is showing the lung power and accusing others.
This is the appellate tribunal. Both sides, you produce the documents and reports. We have already mentioned about detailed, despite detailed order. There is no question of now arguing here.
Manoj, I am seeking your lordship's leave.
Coming back. We are coming.
Manoj, I wanted to mention item 59 for Manoj, if your lordships may take it now. That 59, this is that unfortunate POXO case, Manoj. And
yes,
the difficulty is the commissioner is here and there's some law and order issues, Manoj, which are brewing.
Told in the morning, yes.
Yes, Manoj. So would your lordships take it up now?
Go back. We had on it. Send them back.
Please, Manoj. So commissioner can go back.
The instructions.
I have the instructions. I have the certified copy of the file, Manoj. The ACP and SHO will stay. The commissioner may go back.
My lord, before, in that very matter,
For specific today at 10 p.m. for final hearing, a lot in the afternoon. It's a foreign award passed in my paper about 100 crores. I have subsequently.
What happened? Tell me everything.
Hey, at 2 p.m., the lordship are busy in the afternoon. Remember, they request 26th of April, it's in the first week of January.
I don't appreciate this kind of interference.
my lord is
believe I request to.
I have my lord's
Lordship,
permission to mention.
I must get legal aid, my lordship. So far, I'm not being granted, my lordship.
You please go and get it. I have already passed the order. Now don't waste my time.
Lordships, I request to mention that can I file 2 or 3 page written submission? I request to seek permission to file 2 or 3 page written submission in an IA in Sabrimala matter.
Sabrimala is going on, you can file it.
Obliged, your lordship.
May I please?
Lords, with permission, my lords, may I mention?
My lords, I am troubling my lords today.
Coming up on day after tomorrow, my lord, on 15 pertaining to Kaveri water dispute, my lord. We have moved an application for open hearing, open court hearing, my lord. Lordship may kindly consider this matter is of some importance. In an MA, my lord, an order was passed. Virtually, my lord, giving direction contrary to the main judgment which was rendered in 2018, my lord. That's why we are making a request for open court hearing.
That only the FIR of a commission of a cognizable offence can be registered and investigation shall be instituted.
I'll give a reason. No, your lordship, no, don't, no, will not get angry. This matter can be taken up at 2:30, my lord, together. We'll have a comprehensive hearing at 2:30, my lord. Yes. It can be taken up.
How this kind of repetition are maintained?
Lord, I'll answer on all questions if your lordship. If you not, I can answer them now, my lord, or at 2:30. I can answer all questions now or at 2:30.
No, why should we hear it? Where's the question of answer?
No, my lord. Are your lordship hearing the matter? Yes.
Yes, please argue.
Yes. So your lordship may kindly see, my lord, that if your lordship may kindly see, my lord, the first order, page 95, my lord, of this court, my lord.
Have you filed any appeal?
Yes, my lord.
Then go on before the appeal. Today we have got the report.
So that's what I'm saying, Lord. Yes. That's what I'm saying. Lord, let there be a comprehensive hearing, my lord, or at, my lord, 2:30, since your lordships are hearing it, my lord. Yeah, I cannot, my lord, ask your lordships to, my lord, apply your mind now and then again, my lord. That's why I said, my lord. At 2:30, if your lordship want, otherwise, my lord.
Every day you become a fashion.
No, my lord. What? See, my lord, if you have a pain over here, my lord, we have come to the highest court. We can't go anywhere else.
Their appeal.
No, I'm not. Then I wish to argue it out, my lord, before your lordship passes any order.
Please argue then.
Yes, my lord. So your lordship may kindly see, my lord.
Why should we not look at any document? You have filed the appeal.
The reason is, my lord, I'll give a reason. No, your lordship, no, will not get angry at the first instance, my lord. Your lordship may kindly hear me, my lord. So your lordship may see, my lord, the first order is, my lord, passed, effective order is 10/3/2026, my lord. Where your lordships, my lord, said, my lord, kindly have, my lord, page 95.
Please tell us, you have, the judicial officers have not found you to be a valid voter, right? Your names have been excluded. You have gone in appeal. We have constituted the tribunal. Today we have received the report.
Yes,
Today we have received the report that tribunals are functioning right from today morning.
What I am saying is this.
So what you want to argue for?
Because Mr. Naidu said, my lord, that 9th is the freezing date, my lord. I will not be heard after that. If I am going to be heard today, my lord.
Your appeal is allowed, and if they don't include, then come to us.
So, my lord, are the appeals being heard today, my lord? Is my question, my lord, to the ECI.
Well, you can't blackmail the tribunals like this.
Doing that, my lord, your lordship, my lord, I have not even placed my case, my lord. I have not even placed my case, my lord.
You have filed your...
My lord, today, your lordship, my lord, at the first instance sent me, my lord, to Justice Sivaganam. Now, that order, the substantive of that order, my lord, is three-phase. The first is, my lord, those who are having... No, no, I'm explaining.
They have resolved their MOP. That has been circulated. Yesterday, they have got all the judges on the appellate tribunal. They have learned how to deal with on the online appeals. That training has been completed. The Chief Justice of the High Court has informed us officially that today they have started hearing the appeal. If you have an urgency in your appeal, go and make out a case.
My lord, we are there, my lord. The only problem is, my lord, I'll be very...
Only because your clients can afford to come via Supreme Court. Therefore, we should ignore the other appeal.
No, I can't, my lord, I argue like this, my lord. Then there's no point, my lord. Then I leave it just like that, my lord. If I'm not allowed to argue also, my lord, then what's the point, my lord?
No question of argument.
My lord, the thing is, my lord, your lordship may kindly say, my lord. My lord, your lordship may kindly say. 9th, Mr. Naidu, my lord, says, my lord, that all the list has frozen. Is the list frozen?
Not the final.
My lord, he doesn't even place the matters. The election commission doesn't even place the matters before Justice Sivaganam. Your lordship may see the order, what they do. Just pass the order. They don't even place the orders. They don't know what is happening. The ECI doesn't know what is happening. They don't place it before the court. Your lordship
is not concerned about them. You go.
So because they are supposed to have all the documents.
Somebody without any basis.
Former Chief Justice of the High Court, the appellate tribunal. Why don't you go and argue your appeal there?
My lord, the reason is, my lord, that the freezing date they say is 9. If they make a statement today, my lord, that all appeals are going to be heard, I am not going to come here.
You go there, you argue this,
I am there, my lord, it's not being taken up. There is a practical difficulty, I'm saying, before this court with very folded hands, my lord. There is a practical difficulty. The people are lined up, my lord, the appeals are not being heard, and he says the freezing date is on the 9th. Let the freezing date be extended. That's what I'm saying.
That cannot.
They are nobody to decide it. That will be decided either by the appellate tribunal, or if your appeal is allowed, we will decide.
So, my lord, my only request today is, my lord, with folded hands, my lord, and I'm, my lord, requesting with the greatest humility, my lord, will all the appeals who are there, my lord, will they be decided within a given time frame, or will they come beyond the late? That is our request, and an honest voter, my lord, who was there, my lord. And
same answer, that do you want us now through a judicial order command these thankfully that these former judges, former chief justices have agreed on our request. You want us now put them under pressure to decide how many appeals?
I don't want. What I say is, my lord, the former Chief Justice, a great respected Chief Justice of, my lord, the Honorable Supreme Court of the High Court, my lord, has given 3, my lord, categorical findings. A, those who are having Aadhaar, those who are having passport will fall into the judgment of this court. So, my lord, all those who come under that category in one, my lord, in one swing, they will, my lord, immediately be allowed.
Oh, that is for the appellate tribunal.
Correct, my lord. Correct.
They have themselves, as we understand from a communique by the Chief Justice of the Calcutta High Court, sat in a conference, worked out the manner in which they are going to dispose of the appeal.
Yes, ma'am.
Now, there is a large number of appeals.
Of course, but there is a practical difficulty.
Today, we are not in a position to say that you dispose of X number of appeals every day.
I don't say that. I don't.
Let us see if the Honorable, the former Chief Justice has passed an order. It is expected that the committee of the tribunals, they will follow the same, or if they have already, they will give their reasons for
sharing with you. They have already
ECI chooses. Today, in a particular case, ECI chooses not to place records, or that is to say, not to seriously oppose an application. But there may be cases and cases where ECI feels that they will seriously oppose an application. It has to be left to the ground, granular reality of each and every case.
Before the last date of nomination, whenever anybody came, we volunteered. We have never taken on any technicality. We said that today itself we'll request the Honorable Appellate Forum so that that could be disposed of. And he wants to accuse because we have helped.
If we pass an innocuous order accepting your claim, look at
I don't mind. I don't want my claim to be adjudicated by this court. I'm so sorry, my lord. If that is the idea, my lord, I take everything back. My only prayer, and the only prayer is, my lord, with great respect, my lord, is let, my lord, the appellate tribunal, my lord, hear me within a given time frame so that I'm a mapped voter, my lord, with Aadhaar, with passport. Should I come into the same category?
I believe there are 30 lakh appeals.
Our earlier order can be the same order so far as your clients are concerned, that one of the tribunals will take up your case and dispose it. But to say that it is to be done by tomorrow or day after tomorrow, in your part, there was one particular case where there was a candidate.
He himself represented millets.
Why we gave that specific time frame is because of Section 100 of the Representation of People's Act. Unfair denial of participation as a candidate is a ground to cancel an election. But right to vote will pursue until and unless it is a enormous number of electors. Which under Section 100 does not fall as one of the grounds for cancelling an election.
And if voters, as my brother has pointed out, where again borrow the language of the statute, which can materially affect the election.
Yes, materially.
What I'm saying
not mere omission.
Very important thing.
If an idea is given, my lord,
consider this: a number of 10% of the electorate does not vote, and the winning margin is more than 10%. What will happen?
Only academic
Will the
exercise.
election be set at
Lord,
naught?
Lord, election.
Only academic exercise.
No,
But suppose margin is 5%.
But margin is 2%.
Then
And 15% of the electorate who are mapped could not vote. There may be, we are not expressing any opinion, but definitely we have to
True.
apply our minds on
Your,
that.
your Lordship's main worry would be, my Lord,
You
that those who, your Lordship's main, your Lord,
We are making a very graded approach
of course, my Lord.
to ensure
Yes, my Lord.
that all the rights,
Yes.
including the fundamental duty of the Election Commission as a constitutional body, are balanced and a fair and impartial exercise is undertaken.
If my Lord,
Not to forget, never, never keep this in your mind that the concern of a vigilant voter whose name perhaps correctly or incorrectly is not in the list, is not in our minds.
of course it would be, your Lordship's, my Lord, are men, my Lord, men of wisdom, my Lord, great, my Lord, learning, my Lord. Only one thing, my Lord, if an idea is given.
the very creation of appellate tribunal is that idea.
Yes, my Lord, I know.
To
It
ensure
has been,
that there should be a second
my Lord, it has been a gigantic effort by this court, my Lord. This court has leaned over backward, my Lord, to ensure that the rights are protected. My Lord, my Lord,
You are only talking inclusion. There's an objector filing an appeal.
if
An objector filing an appeal
Objector.
in respect of an inclusion in the electoral roll as per the recommendation of the judicial officer. If that is also allowed, then that person has to be removed from the electoral roll.
Lord, today, my Lord,
They have
what-
done it. There is another that's our worry. There is another.
it has been, my Lord, quite taxing on this court, my Lord, because of the time frame, my Lord. I fully appreciate your Lordship, my Lord, has done a
This
great
is
effort by
the-
700, my Lord,
It is
judicial.
the judicial officers and now the appellate.
Yes, my lords.
So, my Lord,
My lords may
only-
recollect, my lords.
only two
Initially,
submissions,
your
my Lord.
lordships were not even inclined to have an appellate tribunal,
Only two submissions.
saying that one, since the judicial office have been exercising the power granted by your lordship, that should be the one, nobody should sit in appeal. Then my lords have relaxed that one, said that let there be an appellate forum. And these people have their remedies there.
Very vital questions involved, right?
Yes, my lords.
See, we have permitted the constitutional authority with its concern of purity of electoral roll to go into inquisitorial exercise.
Yes, my lords.
If you see the original SIR notice, it talks of the benchmark as 2002 electoral roll.
Yes.
So the SIR that had comments does not touch a person who is in 2002.
Yes, my lords.
But when you flag logical discrepancy, you in fact touch that 2002 electoral roll.
My lords, what we have said is anybody who has been there in that one, they are automatically in.
But then the logic.
Provided, my lords, provided they can put their credentials and track this thing without any discrepancy.
Sir.
Yes, my lords, with great respect, I can demonstrate.
2000, if you
Yes, my lords. Yes.
will examine it definitely.
Indeed, my lords.
But
Yes.
we can tell you the way we read the 2002, your notification, a 2002 electoral roll is fixed. It is not touched. What is touched is people who are relating them to the 2002 roll. like a son whose father is there. He relates to 2002 roll through what? Through a passport, through any other document. 2002 roll is the benchmark. Why? Last election intensive is that. In the logical discrepancy list, and that is why in your final list that you published, you did not delete them.
Well, let's make absolutely there's no question of any deletion.
Not delete
Every person has to submit a form
No, sir.
where they have to establish that it's one and the same person.
Please again examine your
Yes, ma'am.
petition.
I will.
I
will examine.
2002 entered voter does not require to give anything.
Your Lord.
And that was the submission. You were not present.
Well, he has to give a form
Mr. Naidu,
affirming that he is the same person.
when the Bihar SIR was argued,
Yes,
and we understand Bihar SIR is a facsimile of the SIR that we are dealing today, because that's a common SIR. The submission was very clear.
The only difference is
Well, it's the same form, the same method, nothing has been changed.
That is
And
so.
what we have said is that, minutes.
So the submission from ECI was unequivocal.
Yes.
A person in the 2002 electoral roll does not require to give anything.
Millets, he need not prove anything further. Only thing, he is the same person. For that purpose, we have given two columns. The column which reflects 2002 name and the present credentials. If they match, automatically is in. In most of the cases, Millets, unfortunately, they have not taken care to put the correct particulars. They've invited the trouble.
If that is so, please examine the written submissions put in the Bihar SIR
We will.
case.
We will.
It is very clear.
Millets, I take it and I'll just come back to your lordship.
Entire electorate has to upload documents. No.
Millets, no document is needed provided you are there in 2002. Those who have, yes.
Now you are
Millets,
amending your
I'll just demonstrate in one case,
You are
Millets.
deviating from your original
No,
document.
Millets, what has happened, in 2002, somebody is else there. And they have to replicate whatever was there in that one. And they...
Let's not, you are only trying to say that somebody says today that how I will excluded my name, I am there in the 2002 list. You are saying, sir, if you are there in 2002, you are welcome. But in 2002, the name is XYZ. Today you are claiming XYL.
Exactly.
Therefore, the problem is right. XYZ.
That's the only discrepancy. Had they faithfully filled the forms cautiously that the same person, they wouldn't have been, automatically they would have been allowed. What they have said is, that's my alias name.
A 2002 elector does not fill any form.
Millets, they need 2 minutes. Enumeration form is a mandatory one. Form, all that they have to do is, may I just give the practical ones which we have done, Millets? I'll show them to your lordship. So that my lords could appreciate.
Fill up their names.
Yes.
That is it. No
Exactly. It's a ministerial job of filling up the names correctly. If they have not done that.
That is only an format without any documents. That there you disclose that yes, I am there already in 2002. I am not required to.
I am not required to put in any confirmatory document.
Yes, not necessary at all.
Document is
That
for
name itself is enough. Only thing is, the details should match. There ends the matter.
Now what?
I'll just submit a model forms to your lordships. Kindly consider that.
So like
whether there is any
you are
deviation.
submitting model form to someone who has filled up a form.
Beg your lordship's pardon.
You are submitting model form at least to me who has filled up a form. All right.
No, Millets, but the cases where they have not matched, despite their being there in 2002, once they have made a mistake in presenting the present enumeration form, that flags. Otherwise, it's in.
That is not only the filter used in flagging logical discrepancy. There are multiple filters.
Millets.
There are multiple filters like, let us say I am person A.
Yes, Millets.
Son of person B.
Yes, Millets.
My name and father's name matches. But there is a filter that there is another person by the name of C, whose father name is B, that's the same, and they are born within 6 months. That sort of filters are
That's
there.
what we have called logical discrepancy, Millets. That's what we have called logical
That's what
discrepancy.
I am bringing you.
Yes.
When you bring in this logical discrepancy, it actually invokes your constitutional powers. of verification, right? That can never be taken away, it is there.
Yes.
And what you rely on, in our understanding, is section 22 of the Representation of People's Act, that is a suo motu inquiry. And when you go into suo motu inquiry, Mr. Naidu, you examine rule 19 to rule 23 of the registration of electoral votes.
Yes, madam.
They require a hearing upon notice. In this situation, what happened was there was no hearing given. It was only a verification.
After that, we
submitted. That is why we are coming to this. Why we wanted the appellate tribunal when there was a constriction at the first instance verification. We need to protect the due process rights.
May I just submit one thing, Millets? Once we have published the list of logical discrepancies, whatever the variations, Millets, and then based on that one, they're informed, then they can as well submit to the ERO their objections or their justification. How in that process, my lords have said, because of the inadequacy of officers, judicial officers have come into picture.
Been done because the volume of logical discrepancies which were marked and the date for the election was so close, and there was a constitutional issue of trust deficit, which we pointed out, between the people given by the state, inadequate, not literate with regard to the...
The whole issue began there when we wanted adequate manpower, trained ones, that has not been provided.
In this situation, we had to evolve a process. The process, however, had certain departures from Rule 1920. Because 1920, when you see an inquiry, it speaks of a notice, the opportunity of hearing, and opportunity of presentation of documents, hearing being discretionary on the election officer. We could not give hearing wherever necessary by the judicial officers. So we have to leave this open for the appellate tribunal. And that is why our request to both of you, we cannot hurry this process.
Well, as far as the year was concerned, there were hearings happening. Then judicial officers have come. Kindly see, Millets, the justification of logical discrepancy. To this day, after the scrutiny of judicial officers, 47% is the rejection.
Not on the...
Because they have been justified.
Not on the end justifying means. We are on the means, subjecting themselves to the reasonableness and fairness.
Could my lords recollect, Millets? The whole trouble began, when we wanted EROs who have had this quasi-judicial experience. They were not provided. Once we have taken...
Mr. Naidu, it is not a fight between the state and the election commission.
Inadequacy of manpower, Millets, I am submitting.
It's not a blame game. It's a question of the voter being sandwiched between constitutional entities.
Millets, we have given every provision. We have given every assistance.
When we are fully in agreement with you.
Yes, Millets.
From your point of view, you have put your best foot forward. From the state's point of view, they are circumspect. We have decided that in this situation, to ensure a fair and impartial election, the purpose of the court must be enabling and not a adjudicatory exercise of who is right and who is wrong.
Millets, in the orders also, your lordships have chosen the votes very carefully in a very balanced manner. Never an accusing finger, either side.
The very spirit of court's hands-off approach, and if you see Mohinder Singh Gill,
yes, Millets.
Lokhi Kantro Sen,
yes,
each and every case, the courts have intervened to promote fair election.
Millets, we have had every endeavor.
Or interdict an election.
Yes,
and that is our spirit, which we invoked under Article 140.
Precisely, Millets. Even
deploy officers where there was a trust deficit between the state and the constitutional entity responsible for superintendence of roads, that these judicial officers will undertake a verification. But the volume, because we were not able to give the adequate numbers, the volume at which they had to do, there is always a chance of error. Just consider.
I request to.
If I have my lord's permission to mention.
I must get legal aid, my lordship. So far, I'm not being granted, my lordship.
You please go and get it. I have already passed the order. Now don't waste my time.
Lordships, I request to mention that can I file 2 or 3 page written submission? I request to seek permission to file 2 or 3 page written submission in an IA in Sabrimala matter.
Sabrimala is going on, you can file it.
Obliged, Your Lordship.
May I please?
Lords, with permission, my lords, may I mention?
My lords, I am troubling my lords today.
Coming up on day after tomorrow, my lord, on 15 pertaining to Kaveri water dispute, my lord. We have moved an application for open hearing, open court hearing, my lord. Lordship may kindly consider. This matter is of some importance. In an MA, my lord, an order was passed. Virtually, my lord, giving direction contrary to the main judgment which was rendered in 2018, my lord. That's why we are making a request for open court hearing.
No, is it a review?
Review, my lord, review. But
See whether it is to be added in open court.
Please.
we have made an application, my lord. It goes beyond the main judgment.
No, that, okay.
Lords,
My lords, this is a matter for Wednesday, and it's before Justice Narasimha. Unfortunately, he's not there today. My lords, it is a contempt.
When?
Justice Narasimha.
Oh.
My lords,
It's only for today.
my lords, no. My lords, there's a fresh contempt that was filed a week ago. Unfortunately, even the defects have not been able to be listed. It's very important and it's urgent. And we just want it listed on Wednesday.
Urgency, madam.
I beg your pardon?
What is the urgency?
My lords, the urgency is this. My lords, may I explain? This is a recruitment matter in which Justice Narasimha himself had passed a very, very strong order in my favor. Now, the seats, it has come to my knowledge, have been filled at such a fast rate that quite soon I will, essentially be non-suited despite.
Don't want anything on merits. Please tell what do you want now?
I just want it listed, my lord, subject to the my colleagues clearing the defects.
Day after, on Wednesday, Justice Narasimha will be here. You can make a mention before your lordship.
But if it's listed, then I can argue it on that day, my lords.
We will see what can be done.
with the lordship's kind.
I'd be grateful. I'd be grateful, my lord.
If I have my lord's
May I mention a fresh matter?
My lords are allowing.
Will be preferred by
My
the
lords
state.
are allowing it.
We have not allowed or disallowed both.
All right. Okay.
Lordship, the SLP preferred by the state yesterday, Lordship, against the grant of anticipatory bail, Lordship. There's some urgency, Lordship, in the matter. Lordship, I'm praying that if Lordships could grant of anticipatory bail, the state has come, Lordship. The state has come by, it's been passed by court, Lordship, according to us, without territorial jurisdiction at all, Lordship. Lordship, we are only praying that Lordship may hear it on Wednesday. Please, Lords, may I mention? Obliged. Lords, the Karnataka mining matter, Lords, Samaj Parivartan, Lords, we had mentioned it in January. Lords, there are.
Get for the turn. Every matter is important.
Lords, may I only pray for some date that may be.
We can't promise anything. You know it, question bench is going on. After that, we will see what is being done.
If I have lord's permission to mention an urgent oil and gas.
Obliged.
What has happened in Bihar is, Lord, the Municipal Corporation Act has been amended to actually disempower, Lord, the mayor from choosing his empowered committee.
So what?
I challenged it, Lord, that was there was no interim.
Challenge before the High Court first. Very good.
That order was appealed before your Lordship. I have taken out
High Court has adjourned for Monday, therefore Supreme Court. Why it have listed on Friday, therefore Supreme Court. Only notice have been issued. Everything is being checked.
one more line, Lord. I listed that, Lord.
Save the jurisdiction of this court for important matter.
I'll just say one more line. They have directed that the empowered committees be appointed between 15th and 20th, and that's what
Whatever they have done, the High Court must have applied its mind. We are not sitting here like every day, keep on monitoring on with the radar what's happening there.
This is a direction of the government.
Thank you very much. Thank you. No.
Lords, if I have my permission to mention an urgent oil and gas tender matter, my lords, in this case, the financial bid is already opened, my lords, and the respondent may grant the letter of award any moment, my lords. Oil and gas tender matter, my lords. The financial bid is already opened, my lords. The letter of award may be granted any time. I'm requesting urgent listing, my lords.
What's the urgency in it? If you
My lords,
decide, we will come.
my lords, the bid has already, my lords, the bid has already opened, my lords.
All right, it's all right. All early hearings are rejected. Now start.
With your Lordship's permission.
Wasting time. We have already told you within 2 days matter will be listed. What is the great hurry? Thank you. Thank you very much. Item 11. Let it be remain a difficulty, but you can't do anything.
With your Lordship's permission, may I mention a matter? My lords, it's a leave granted matter. My lords may give a fixed date. The respondent number 1 is 80 years old and suffers from several.
We will see what is to be done. No promise. Thank you.
My lord, the other.
Item 11.
In item 11, I'm requesting a short pass over, my lords.
What is password issue notice? Issue notice.
Grateful, my lords.
Item 12.
Application.
Please wait. Milords, we have sought declaration of section 2, 3, 4 and 8A of the Dowry Prohibition Act, section 2 and 3 of Protection of Women from the Domestic Violence Act, section 498A of IPC, and section 12(1)(c) of Hindu Marriage Act as.
The only mistake committed is that last time some exemplary course should have been imposed.
Milords, may I say that? Milords, may I say that? Milords, the decision has not been made on merits. There was no effective hearing in that matter. Milords, under Article 2 of International
How
Covenant.
the office is entertaining the registry when the matter has been dismissed already?
Milords, it's an illegal dismissal. It is in violation of Article 1 and.
Dismissal?
Milords.
Be then honorable.
No, Milords, there are no. It's by a non-speaking order.
And you are the same petitioner.
But Milords, it was by a non-speaking order. Justice has not been done, Milords. Milords, people have a right to justice and Article 2 is valid. Milords, Article 2 of International Covenant on International Civil and.
The petitioner had earlier filed repetition civil number 68/2025 seeking identical relief. A coordinate bench headed by the then Honorable Chief Justice dismissed that petition on 3rd February 2025. A coordinate bench, a coordinate bench of this court dismissed that petition on 3rd February 2025. The instant petition from a perpetually in public interest has been filed, claiming that the earlier petition was dismissed by a non-speaking order. We find the argument totally frivolous and uncalled for. While dismissing the petition, the petitioner is cautioned in case he indulges in filing such kind of petition in future, there shall be exemplary costs imposed on.
Milords, may I mention? Milords, may I also mention?
Don't waste our time, please.
People's rights have been.
Next item.
Yeah. Now, my lords, here there are two cases on your lordship's cause list today. My lords, one is serial number 13 and the other is serial number 49. Now, sorry, I'll just explain it to you, my lords. As far as 49 is concerned, it's a writ petition in which your lordships have already issued notice. 49. Now, on that, at midnight or something, we have been served with a reply.
We have filed a status report. Status report.
All right, I haven't even seen it.
It's a status report which the high-powered committee has filed, my lords, in response to the writ petition which they have filed, item 49. That unfortunately could not be filed earlier. We filed it yesterday night. So that's not on record.
You have filed your reply.
I'm appearing for the high-powered committee. So
but you have filed reply to them.
A status report because it's not adversarial according to us.
That's right.
Yes, we have filed a status report dealing with all the submissions which they have made in the writ petition.
Yes, so that is that has come at very late at night, so we haven't had a chance to study it. So I am just suggesting to the court that as far as serial number 49, on which your lordships have issued notice and on which they say that they have submitted, your lordship may call out the matter after 2 weeks is my request, and thereafter, my lord, we'll respond. Now on that. Yes, on that aspect, I should also tell the court, I will have a note which I will. Not a counter, my lord.
It's a status report in writ petition in 1228 of 2025.
1228. That's a separate petition.
Why is it 20?
Petition Now, may I also make a suggestion with regard to serial number 13 on the call. Now, 13 is an MA, where again, I have some suggestions and there appear to be certain factual errors which have occurred in the order. So, in the original order. So on that, I have a note which I will share with my learned friends, because certain historical facts, we don't want those historical facts, if they are inaccurate, to remain in the court's order. So I am just suggesting to the court, since your lordship is putting forth.
Adjudicated any historical.
No, you're right, absolutely right. But
That some passing reference.
that's right. So I'll just broadly tell you what is. Sorry.
I request to.
If I have my lord's permission to mention.
I must get legal aid, my lordship. So far, I am not being granted, my lordship.
You please go and get it. I have already passed the order. Now don't waste my time.
Lordships, I request to mention that can I file 2 or 3 page written submission? I request to.
If I have my lord's permission to mention.
I must get legal aid, my lordship. So far, I am not being granted, my lordship.
You please go and get it. I have already passed the order. Now don't waste my time.
Lordships, I request to mention that can I file 2 or 3 page written submission? I request to seek permission to file 2 or 3 page written submission in an IA in Sabrimala matter.
Sabrimala is going on, you can file.
Obliged, your lordship.
May I please?
Lords, with permission, my lords, may I mention?
My lords, I am troubling my lords today.
Coming up on day after tomorrow, my lord, on 15 pertaining to Kaveri water dispute, my lord. We have moved an application for open hearing, open court hearing, my lord. Lordship may kindly consider. This matter is of some importance. In an MA, my lord, an order was passed. Virtually, my lord, giving direction contrary to the main judgment which was rendered in 2018, my lord. That's why we are making a request for open court hearing.
No, is it a review?
Review, my lord, review petition.
See whether it is to be had in open court.
Please. Lord, we have made an application, my lord. It goes beyond the main judgment.
No, that,
Lords,
My lords, this is a matter for Wednesday, and it's before Justice Narasimha. Unfortunately, he's not there today. My lords, it is a contempt. Justice Narasimha.
Oh.
My lords.
It's only for today.
My lords, no. My lords, there's a fresh contempt that was filed a week ago. Unfortunately, even the defects have not been able to be listed. It's very important and it's urgent. And we just want it listed on Wednesday. I beg your pardon?
What is the urgency?
My lords, the urgency is this. My lords, may I explain? This is a recruitment matter in which Justice Narasimha himself had passed a very, very strong order in my favor. Now, the seats, it has come to my knowledge, have been filled at such a fast rate that quite soon I will, essentially be non-suited despite.
Don't want anything on merits. Please tell what do you want now?
I just want it listed, my lord, subject to the my colleagues clearing the defects.
Day after, on Wednesday, Justice Narasimha will be here. You can make a mention before your lordship.
But if it's listed, then I can argue it on that day, my lords.
We will see what can be done.
With the lordship's kind.
I'd be grateful. I'd be grateful.
If I have my
Lordship,
lord's
may I mention a fresh matter?
My lords are allowed.
Will be preferred by
My
the
lords
state.
are allowing it.
We have not allowed or disallowed both.
All right. Okay.
Lordship,
may I?
Lordship, the
may I
SLP
permit to
preferred by
mention
the
that
state
Karnataka
yesterday,
very
Lordship, against the grant of anticipatory bail, Lordship.
I request to.
If I have my lord's permission to mention.
I must get legal aid, my lordship. So far, I am not being granted, my lordship.
You please go and get it. I have already passed the order. Now don't waste my time. Sorry.
To mention serial number 46 and 46-1. This matter was specifically fixed today at 2 p.m. for final hearing. My lord, this is arising out of a foreign award which has been ordered to be enforced by the Madras High Court. My lord, obviously your lordships are busy this afternoon.
Please wait for the turn. This is not the way we, just wait, we will take up your matter. It's not that we will not take up.
Very well.
May I please use this? Sorry, sir.
Item 56.
Yes, my lords, may I address your lordship?
Can I come? Please, please.
When is Kora, we were there right now. All of them were there in the.
I have the.
No, sir, I think
I have the pleasure of representing them.
Tell them to bring here also. How can?
Yes, my lords. They had Justice Bindal's farewell was there.
Representation.
No reservation.
There's a saying in Bengali.
Yes, my lord.
That the darkest place is below the lamp.
Yes. Correct.
Don't make it the darkest place.
No, Dr. Menaka and I are not here, my lords, to oppose.
No, my lords, we accept your lordship's decision entirely and support. We want to make it possible.
The best part of the Supreme Court members of the bar, we are broadly using the word.
Yes.
That SCBA also very graciously themselves.
Score also.
I think.
Absolutely, my lords.
We have just come here
We
to say this.
welcome it,
We leave
my
it to your
lords.
lordship.
We welcome your lordship's decision on this.
May I also be permitted minutes? May I also be permitted minutes to assist minutes on 1 point minutes? If
and but
with permission minutes, just one small issue minutes. If
there is no need, you can tell Dr. Menka or tell Gaurav whatever you want to say.
I am for an interview. Minutes, I am an advocate on record here. Minutes, I have been a former member. Minutes, just two aspects minutes may consider when one is minutes whether this petition, as it is filed, it is asking for representation on the basis of exclusion minutes.
We know that you are opposing in the name of suggestion.
I am not minutes. Not at all, minutes. Not at all. In fact, I welcome minutes the step the SCB and the bar councils have taken minutes. These are the important issues minutes because advocates on record are a separate class minutes because the.
All right, thank you very much. Thank you. Now tell us which are the OP, the one is president, then you have vice
Page
president.
38, lordship. Page 38. 38 have all the posts, lordship may whichever two posts and 1/3 of the executive members. Lordship have page 38.
Why don't we follow you just discuss? Dr. Menka.
Yes, my lord.
You and Gaurav, all of you just.
Yes.
Yes. Yes.
We'll do that. We'll do that.
So 2 posts and 2 members from the executive minutes. So whatever lordship has just decided, whatever your lordship said, we are all on the same page.
We welcome it.
Yes.
We want to see some change, so
Absolutely.
welcome it.
Whatever your lordship think fit is proper minutes.
Yes, always, my lords.
Yeah, what should we do? We have secretary.
Secretary, yes.
Yes.
So we can go for secretary.
Secretary,
Very
yes.
well, my lords.
And we have very, I think all of us have very pleasant experience of
Pragya.
Pragya, she has done a very commendable job.
Amazing, yes. Amazing, yes. So secretary can be one, it can be treasurer or joint treasurer, whatever your lordship.
As your lordship sees fit, my lords.
Dr. Menka, you were saying something?
No, my lords, as your lordship sees fit. Secretary, treasurer, maybe both positions.
SCB is started with treasurer. SCB is started with treasurer.
One or only two?
2 will be better. It may be that they will normally get elected also, but.
Then joint treasurer can be.
Right.
Very well.
Very well.
Very well.
Very well. And 2 posts in the executive members.
And 2 executive.
Yes, ma'am.
Say the issue pertains to ensuring adequate representation to women advocates on record in the composition of executive committee of office bearers stroke executive committee of the Supreme Court Advocates on Record Association.
I don't know that
Both sides have graciously and fairly, on our suggestion, I agree that in the ensuing election of SCORA, the post of secretary and joint treasurer and 2 executive members may be earmarked for representation of the women advocates on record. When say invoking our powers under Article 142 of the Constitution, be ordered a court. Now we are happy.
The time they
We
will.
are happy now.
Minutes, the larger issues were involved, minutes, because then minutes may also would have considered at the level of entry also minutes. The question of these are the larger issues in context of only AOR's minutes I was submitting.
As
I'm saying whether there's a requirement to extend the time or SCORA will be able to do it in this time frame.
The schedule remains the same.
Remains the same. There's no problem, Melody.
All right.
Yes, absolutely.
Nomination is anyway starting from 15th April until 20th.
No difficulty. I just wanted to inquire. Grateful to your lordship.
No problem. We're also very grateful, my lords.
Thank you very much.
Lords, 57, my lords, I'm only aggrieved with the non-grant of stay insofar as the proceedings are concerned, and I'll tell you lordships why.
Item 57.
57, my lords, this non-grant of stay, my lords, is my only worry, and I'll tell you lordships why.
We shouldn't entertain this kind of.
No, I'll tell you lordships why, my lords. Lordship may kindly see, after the FIR gets filed, there is a closure report that comes to be filed by the CBI. While, my lord, setting aside the closure report and order further investigation, Lordship may kindly see what the order passed by at page 206. Lordship may kindly see. 206 says, my lords, that insofar as this entire final report is concerned, it does not say and it does not adhere to the order passed by the High Court while transferring the matter to CBI, which says, please find out the gamut of the so-called scam insofar as the number of people who could be victims. CBI makes a specific, my lords, argument saying that we could not find any single victim insofar as this company or the scam is concerned. My lords, the
state of Mizoram is the biggest victim.
My lords, and that
the state of Mizoram is the biggest victim.
My lords, and my lords, that is the
your public servant, you swindle away the name of the state to permit a criminal to perpetrate multi-level
my
murder.
lords, but that is what the CBI says has not happened. When it filed the
us to write all these things in the order.
No, my lords, I am only requesting, my lord, lordship.
Frivolous petition dismissed. The moment we will write 2 lines, it will become problem for you.
Lordship, I have compiled a brief note for your lordship's perusal. Madam, I would request you to please pass it on.
See, Mr. Diwan, probably you were not there last time. There was just only very preliminary observation being said. Not prima facie, only preliminary observation. Now this IRP is under cloud. Whatever may be good reason.
I have nothing to say on that, but I have something to say on the other aspects. Because we received a copy of the report, which was made only on Saturday. And this Saturday, after the order came to be passed, we were not aware of the application being made, etc. So I am just, I don't want to get into it. First of all, I have indicated to, as far as my client is concerned, I am not saying anything at all as far as the IRP substitution is concerned. Please go ahead with that, because if there's a genuine problem on that. But on the rest of it, we have something to say, which is why we filed an application for, which we've served on the amicus, for recall, so that your lordships can then adjust the equities, etc. appropriately. So I'm suggesting, I mean, we can do it today, but if they want some time, then on with regards.
Response is ready, you can give, we can keep it.
Yes, yes, I have a submission. This is my recall.
Then we may examine this response also.
Can I take 1 minute, my lord? My lord, we are appearing for one of the banks, IFC. I'll just take 2 minutes. My lord, your lordship's earlier order classified the entities into 2 broad buckets. NBCC, unfinished projects as 1 bucket, and finished projects as another bucket. We are a case where, my lord, our project is completely finished, it is operational, it is functional even today, and there is a default. We don't have any problems of construction or a home buyer, nothing. It's all working. Only problem is default. So, my lord, this is Not as originally conceived, a separate CRP, CIRP, or whoever can be occupied to do that. I'm the only financial creditor. I hold 85% stake in the COC. So what has happened? Earlier order, your lordship directed us to go to NCLAT, which we have done. Our IA is coming on Friday. But day before yesterday's order, my lord, please see one paragraph your lordship may see. Para 4 and para 5. Which, my lord, if we can show only one suggestion, very respectfully, your lordship's kind consideration. If your lordship sees para 4, do it please. Mary only para 4 and 5, my lord. Although, as this is pointed out by so-and-so learned senior counsel, the IRP has challenged the suspension order before the Delhi High Court. It seems to us that the projects, meanwhile, must be completed under the court-monitored action. Proprietary demands that the IRP, till he is fully exonerated by the court or any other prescribed authority, should distance himself from the ongoing proceeding. I am appearing for the IBBI in the Delhi High Court against this IRP.
At your instance,
and we have filed an appeal before the Delhi High. They filed a we have responded. We therefore find merit in the recommendations made by the learned amicus that a court-monitored mechanism be adopted to ensure the completion of projects by NBCC takes place without any hindrance. Para 5. At this junction, we hasten to note that there are approximately 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion by way of judgment dated 12/12/2024 and order dated 5/2/2026. In our considered opinion, the issues relating to the remaining projects also ought to be administered within the same court-monitored framework. Accordingly, the underlying policy with respect to all projects, whether fully completed, substantially or partially completed, or which are lying incomplete and inactive, including those which have been handed over to NBCC, shall be determined by a common authority that may be set up by this court. Not 5 of them form one cluster. There is no difficulty at all. Substantially, partially, incomplete, or inactive, they're all form. Our projects are totally completed and it is operational, it's functioning, and yet default is happening. So we are moved an IA before, as per your lordship's previous direction, earlier direction, we have all been asked to go to the NCLAT to fight our rights. We have filed our IA. It's coming up on Friday. So can completed projects alone be taken out of this list? Rest of them, my lord, they form a one class. There is no difficulty.
No, we have something else to say, because if it was original appeal was confined to 16, our respectful submission is that it ought not to be expanded to 30. I don't know what he might. I'm not for a moment opposing what is being suggested just now. But suddenly from the scope, because the balance 14 projects are pending before NCLAT. They are pending. They were not the subject matter of the original appeal.
This was only during the course of very brief hearing.
Yes, brief hearing.
This was our idea, because if 16 projects under a court-monitored committee continues and those projects are completed, or the home buyers in those projects are to their satisfaction able to achieve their and the other projects are maybe that's why we use the word partially incomplete or substantially.
Correct. But please hear us on this, because it was not the scope. Your lordships disposed of the appeal. Now everybody is before NCLAT.
I'm appearing for the home buyers,
appearing
for the home buyers. 2011.
I take serious objection. The MA ought to have been served on every party. That's the least which the amicus curiae must do. The second is that at least he must serve us a copy of the report. Without having a copy of the application, no notice served on an MA, a report filed, served on me after the order is passed. Your lordships have used the expression, in fact, over here, which speaks about propriety. I would respectfully submit that propriety at a minimum requires that in a disposed of case, when a miscellaneous application is filed, at least it must be served on the parties along with supporting documents. That's the least.
No, supporting documents is, it's not, everything is admitted on record that IRP has been found guilty of something.
No, it's not, my lords, I'm sorry.
Placed under suspension. Now the committee which has been looking after the Apex committee is headless. All these are a matter of record.
I have no problem with that. I started by saying that, look, if there is some practical difficulty, in fact, what ought to have happened in a situation is go to NCLAT and get it substituted by NCLAT. How do you, in a disposed of appeal, come over here, file a report, don't serve it, and secure an order like this, which is a tremendous variation?
No, you see, amicus has no interest in the matter. There is no question of any securing order by him. This order is only because he pointed out this suspension part to our information.
So that may be retained, my lord. Para 4 may be
Because by
retained.
virtue of the approval, we granted to that order. Therefore, because by virtue of an order passed by us, if a person whose conduct unfortunately for any reason is under cloud, that's why we said that there has to be a court monitor committee.
So, my lords, on that I started by saying I have no problem, but please confine it to para 4.
Only to 16 projects.
Lord, may
You consider it.
Yes. Yes,
we
also
just
projects.
make one
Problem.
There is a submission, my lord, for the home buyer. The submission is this: we are equally placed, other than 16 project, my lord, and these projects are also 2010-11. They are incomplete, and your lordship had rightly said.
That part.
Yes, my lord. Grateful.
Our query was that in 16 projects which we are giving to suppose the court monitoring committee, those projects will be completed. Part of the home buyers will be happy. Rest will be again making.
Exactly, my lord.
But on that,
Propose
problem,
that we support it, my lord.
that there's no problem. 16 was what the scope of the original appeal is. If someone wants to increase, your lordship appointed the amicus to assist the NCLAT proceedings. Now, over there, we will have our day in court and we will assist over there. So, any variation to be done because of exigencies, etc., can certainly be done before NCLAT. But suddenly to come over here, expand the scope beyond the original appeal.
NCLAT is not going to regulate our proceedings.
Correct.
No, of course not. But your lordship disposed of the appeal.
That is the court initiative only to bring parity among all the home buyers.
Correct.
And to ensure that some of them do not feel that they have been left behind.
No, those are
equally placed.
Those are delivered projects, the other remaining projects.
Complete projects where everything is complete.
Yes.
No, they are not. They are not completed projects.
My case, one minute, don't mix up.
But
Not
I
in my
have
case,
one
I
thing.
say I can say it in an affidavit, complete project.
We find a merit even in complete projects. Suppose the financial institutions are yet to recover.
Yes. No, so that can be worked out before NCLAT, because that issue which your lordship is correctly placing before me is actually pending before NCLAT. NCLAT itself had 17 on one side, out of which one is completely complete. So that was not part of the 16 which your lordship held. And then you had the balance projects. That issue is under consideration of NCLAT.
That said, that may not be a ground for us not to now just ignore the ground reality that's going to happen.
There is no ground reality, my lords.
IRP was there, then this issue was not there. Because IRP was there and he was IRP for the entire company, for the entire entity he was there.
No problem, my lords. You can, as I said, for the 16 substitute IRP, we have no problem with that.
Lord,
We have no problem with that.
Lord, may I just bring one fact to my lord's notice? Mr. Just 1 minute. Lord, a financial creditor in relation to the 16 projects, my lord, where the apex court committee was constituted and where your lordships, my lord, have noted that IRP is now suspended. Lord, we appear for the financial creditors. The composition, my lord, that was determined by NCLAT, which your lordships found favor with, was total 5-member committee, IRP who now goes out. My lord, 2 members of the creditors, 2 largest creditors. One was NBCC, 4th was an independent person. Lord, all the other persons are still there. My lord, this committee has done considerable work. Instead of having, my lord, a completely new committee, if the IRP goes out, any judge or any person your lordships thinks appropriate can replace the IRP.
We will appoint an independent committee. Some of the ACC, there is an apparent conflict of interest also.
Apex committee.
These are there.
But then I have only one request. If your lordships are inclined to appoint a completely fresh committee, my lord, my only request is, like your lordships were pleased on the last occasion to give representation to the creditors. Your lordships gave us 2 seats, my lord, out of 5. My lord, I am requesting, my lord, that your lordships may, my lord, appoint any new committee will be with your lordships completely. I am only praying, my lord, let the financial creditors continue to have that representation.
And the home buyers also.
I have no difficulty.
You see, financial creditor, in any case, their interests will have to be protected, and I think earlier orders are there adequate enough. We can.
My lord, only thing that happened.
All directions we can.
Only thing that happened, my lord, in the committee, my lord, as proposed by the learned amicus, which is, my lord, following what happened in the subsidiary matter. My lord, none of the creditor representatives are inside the committee. So what happened is all our suggestions and inputs are now externalized. If you are a part of the committee, my lord, when the committee itself is considering, there will be an internalized input that would come.
Our experience of appointing independent committees in some of this kind of projects has fortunately been quite satisfying. We will not say that it has been really outstanding achievements, but wherever in certain other projects, such committees have been constituted. at least home buyers' interest has been adequately.
Correct.
Financial institutions' interest has also been to some extent protected. And there is at least no sense of insecurity created as far as their interest is concerned. So we are quite confident
My
that-
lords are right, but if you may just bring to my lord's notice, just a minute, serious.
May I
My lord,
make
if
a
you may
lord's
bring to my lord's kind notice, what happened is, my lords are completely right, my lord, I respectfully bow down. But in some of the committees, my lord, what happened is where the creditors' inputs were not considered at all, there are litigations now coming before this honorable court. All that I am requesting is, lordships may have home buyers representatives, if, my lord, that is a request that is being made and if it appeals to my lords. My lord, your lordships may only provide, unlike the Supertech realtors, my lord, where none of the creditors' representatives were on that particular board, lordships may kindly have representation from the, my lord, creditor side also, like your lordships were pleased to do in this very matter on the last occasion.
That part, once we constitute the committee, will pass an order in open court only.
Because, my lord, para
Maybe
6,
that Mr. Diwan has filed some objection, Mr. Jain, you may consider those one also.
in para 6, just a minute. My lord, in para 6, your lordships were pleased to.
We filed a recalling.
In the submissions, because we have traveled substantial
Certainly good.
distance. Most of us have, we have taken.
The word substantial creates problem.
No.
If you say,
We are saying full. I'm saying full. It is operational. It's working and they are defaulting.
if you say the.
In spite of working, they are defaulting.
We will happy a statement if you say project complete, home buyers possession delivered, financial institutions paid, transfer, sale deeds have been executed, conveyance deeds are.
Share deed registration, share deed.
Yes, we are very happy.
Lord, in my case, no home buyers are involved. It's a mall cum hotel, completely functional, and they are defaulting. Therefore, my lord, can I move an IA? Might be permitted to move.
Because the details of all those projects.
Yes,
are very.
we'll keep it.
Like to.
Maybe.
Yes,
Lordship, in your order dated 5th February, your lordship, para 20 states that the amicus may approach this bench in case there is any impediment to the implementation of your honorable court's order. Consequently, once the IBBI passed the order against the IRP, there was an evident impediment in the implementation of this bench's order. Hence, I move that petition. At the same time, your lordship, you need to factor in this, that Supertech is a legal entity registered under the Companies Act. It's a corporate debtor. It not only has projects, it has other things. It has investments, for instance. It has subsidiaries, over 24 subsidiaries. It has litigations. It has relational party loans and transactions. All those would need to be taken care of by an entity. Currently, what do we have? Currently, in the absence of IRP, we have nothing. If we agree to the proposition that it is only, if ACC is only for the 16 projects, then who looks after the rest of the company? What happens to the surplus of non-16, or say a receivable from a subsidiary? Who manages the boards of the subsidiaries? There are issues which the company as an entity has to handle. There has to be a credible body like the board of directors discharging the functions of the board of directors. If not ACC, then who? So in the current dispensation, there was no COC, sir. And if ACC is only looking after 16 projects, then who's looking after non-16 and rest of the company? Only the IRP. I'm sure that was not the conception of the honorable bench. So the company has to be looked after. The company's interests go far beyond 16 projects. And home buyers we need to put in a structure in place that protects the interests of the home buyers, and then the lenders and the authorities.
Anyway, we'll put in our objections in 3 days' time, and your lordship may list it next week or whatever.
Yes, also you can give your.
Yes, my lord, we will also.
But even on the composition, my lord, we'll place our submission.
Take it on next Monday then.
Yes, very well, very well.
But even on composition, my lord, we'll place our submission. Your lordships invited it at para 6.
Your lordships,
Lordship, may I make one request?
Can it be next Friday, my lord?
Lordship's notice, just that I may failing in my duty to inform that there has been an amendment in the code, my lord, on 5th of April 2026. And the new guidelines have come on 7th of April 2026, which the amicus is not aware of it, and probably he did not be informed to the court also, my lord. Lordship may appoint the IRB, but that amendments have to be taken into consideration because it has now come as a project-wise, my lord, not independent, not as a composite, my lord. And somebody in grieved out have to go independently to the NCLAT, my lord, not like in a cluster, my lord.
Lordship, project-wise committees have not been formed so far.
This is the amendment.
In the NCLAT's order of December 24, the project-wise committees also had a role in finances because the NCLAT stated that the ACC has to conform to RERA regulation of apportioning the funds into 70-30 ratio, wherein 30 would meet the dues of the lenders and the authorities. However, this honorable bench ordered that first, the project has to be completed, home buyers' interests have to be met, and only subsequently the surplus has to be diverted to pay the dues of such and such. Now, so the project level committee no longer have a financial role. And the project level committees have not been constituted.
To have a separate committee for each project because
at the same time, sir, since projects are spread in different places and the lenders are different, the home buyers are different, in some cases the authorities are also different. And the Apex committee may not be physically capable of supervising the implementation of the NBCC project at all the places or monitoring the grievances of all those projects. Consequently, some kind of a structure which maybe the ACC can think of or someone else, that some kind of thing needs to be there at the project level to handle the project related issue, except for the financial part.
ACC is the Apex Code.
Can it be on 24th, Millard?
May I bring the notice to amendments?
Suggestions, if any, to the proposal, to the recommendations made by the London Micros
amendments,
which are duly incorporated in our order dated 10th April 2026, may be made within 3 days. Post this matter for further consideration.
Can it be on 24th? 24th or 27th, Millard? Home buyers have to file also.
Next Monday because the urgency is there.
Yes, yes.
There is nobody is working and we have stopped there. There is an interim order.
Yes, and Manoj, may I have handed in an MA that may be registered, Manoj. So I'll put in my replies also separately.
I have passed on the amendment also, my lord.
And I may be given a copy of the MA.
Section 526. Next please. 526.
Yes, please pass.
I have passed on the amendment, my lord, for your lordship, please.
Right, we'll consider them together. We give to the amicus.
Yes, we. Amicus.
Manoj, would that MA be numbered? Which we have I've taken out an MA with e-file, that's it.
You ask your junior to file now in the registry because
No, we'll file in the registry. They say that because it's a disposed of appeal, they don't number it.
Permission would be required.
Without your permission.
Permission would be required, my lord.
the registry directed to assign the number. Post this MA on the date fixed.
Grateful.
So great. Intervention may be allowed.
My lords, I beg to appear for the state, my lords. The file and record is here. We filed a status report. It may not be on record, my lords. I'm carrying copies. My lords, broadly, if your lordships will see, my lords, the charge sheet is actually filed under the enhanced sections, my lords, of POCSO. In fact, the enhancement happened on the very next day, my lords, after the inquest report and postmortem. So we are carrying, my lords, your lordships had permitted the commissioner to go back, but the, my lords, ACP, the SHO are here. Original files, because the charge sheet has been filed and cognizance is also taken, my lord.
That is what is happening, and sometimes it's quite disturbing that suddenly somebody wants to come to the court. Then you say the charge sheet has been filed.
In this case, the charge sheet was actually filed even before they came. So the date of the charge sheet here is, my lords, 3rd of April 2026. So on the writ petition does not disclose it, my lords, but the charge sheet was filed on 3rd of April 2026 and cognizance was also taken.
My lord, I have certain things to say. If you see what the status report which has been filed, on the last date of hearing, I had submitted specifically that there seems to be an attempt to shield the hospitals concerned. One, they have not served the hospitals despite your lordship's directions. They are yet to come on record. Secondly, you will find that the policemen have gone around, recorded statements of people saying this, that the child was found not breathing at that point of time. The video is speaking otherwise. Why don't they inquire into that? An SIT needs to be constituted because there seems to be a concerted effort to see to it that this is completely taken away from the record. Even now, despite the fact that there were directions from this court, and even the postmortem does not direct an inquiry towards the aspect of sexual assault. This is the manner in which these investigations have gone on. One can really...
Charge sheet has been filed under which provision?
Please, my lord.
Have you mentioned any charge sheet?
The charge sheet I have yet to see. They are yet to file that record. I'll have to look into that. But the status report which they have served on us...
Status report, your
Hospital is concerned. We have been served on
we've
Saturday night.
served the hospitals also.
Served on Saturday.
Lordships will see para 18 of the status report, my lords. The charge sheet has been filed
Respondent 4, my lords.
under section 66, which corresponds to, my lords, section 376A, 5 and 6 of POCSO Act, which is aggravated. Lordships will have para 18, my lords.
And murder and.
No, my lord, here the issue is that when the child was alive, do private hospitals have the discretion to say that we will not treat you, we will not admit you,
Then that is not a.
and the child dies thereafter?
That is not a part of prosecution.
No, that is also a part of it.
That's not a part of prosecution.
But what I am trying to say is, my lord,
Your main thrust will be against the offender who has.
no, that as well. As far as the offender is concerned, when the FIR came into place,
In the nature of, I think 357B. of
no, my
old
lord.
code.
Here, in fact, offences independently are attracted against the hospital in relation to 304. Because at the time when the child was brought there, if that aid was given at that point of time, the child would have survived. You, in fact, hasten the death of the child by not admitting the child and giving that child the treatment at that point of time, especially when there are directions from this honorable court that nobody can refuse. That is what is also bothering me. We have lost a life, and especially a 4-year-old child, because that medical intervention didn't happen.
We have,
Not one hospital, 2 hospitals, one after the other.
we have penal provisions.
Apart from that, there are penal provisions in relation to that.
We have penal provisions for the failure to record a report. Record a report at the police station in respect of a sexual crime.
Even that was not done. If your lordship sees,
Hospitals will not record it, right?
no, I'm not saying that.
Just examine according, in light of your submission, which is quite distressing that the hospitals did not extend medical relief, and that would be a breach of Article 21 rights in the form of a constitution tort. Whether that would.
No, it would not be a tort alone, my lord.
That is what we should expect.
In a normal case where it's a
Whether-
situation,
Whether this would transcend to crime.
yes, it would.
What would be the offense according to you? 304.
I would say 302 at the highest, but 304 at a lesser degree. Because you are fully aware of the fact that there could be a situation where the child may not survive. You have that knowledge. And the police shuts its eye in relation to that, records statements contrary to the situation in the. I will only urge one thing, my lord. Your lordship may kindly see.
The prosecution should be against the principal accused.
The principal accused also, my lord, initially was to shield him.
Penumbral players.
I agree to one aspect, my lord. As far as that is concerned, even the FIR, initially, if your lordship sees the FIR doesn't talk about rape at all. Where is that? Recording.
Lying last seen together and the recovery.
My lords, last seen together, there is also.
Any, you've sent the blood and the other.
Yes, my lords.
Fluids for DNA examination.
Yes, my lords.
And also of the accused.
Yes, my lords. The
That
report.
whether any bodily fluids of the
Yes.
accused found on the
Yes,
body of the deceased.
Yes, my lords.
If your lord.
There is one more additional.
These are the areas perhaps which are.
My lord,
There
there
is
are
more
2 areas which
focus
are
to be
disturbing.
given, rather than we understand your concern as a bereaved parent. But if you look at it from the perspective of investigation of the crime, it should be targeted more against the person against whom the allegation is one of murder and rape. And the clear investigational purposes.
Now, my lord, shall we look at it from that dimension?
Mr.
I will take you through that dimension as well.
Yes, that is.
My friend is saying that everything was done. Kindly see that the incident happens on 16th of March. Till 17th of March, 3:30 in the morning, the next day, around 18 hours of difference is there in even getting the first information report in place. And what does my friend, can I?
3:30 in the morning, Malad. It's not.
3:30 in the morning is what I'm saying.
It's 3:30 in the morning.
Incident is happening at 6:30 in the evening. The aspect of the child having been brought dead is recorded at the hospital at 21:55 hours. Why is it that the FIR is coming into place at 3:30 in the morning, my lord? Look at the time period which has elapsed. And the FIR which is coming into place is an FIR which is coming into place only in relation to 302. There is no mention in the FIR of any of the offenses of aggravated assault or in relation to rape, which is what I pointed out on the last date of hearing.
Sorry, I was just going through the status report.
Please, Your Lordship.
We better just examine the charge sheet.
Very well. Let them.
Because we would first like the victim's family's full satisfaction. The law will never be able to really, to our satisfaction, its moment will be fall short of unless the victim's family is satisfied. So, but at the same time, in our over anxiety, constituting SIT may unnecessarily may not further delay the proceeding. From that angle, you just examine.
My lord, I have only two concerns. One, the day the report is tried to be lodged by the father, he gets beaten up at the police station.
See,
a daily wager, a laborer, this is the manner in which they treat him. And now they are hounding him, saying this, that you have gone to the Supreme Court, please withdraw your petition. This is the manner in which he is being treated.
Did he receive this sort of a threat?
Yes. And he has been shifted from Uttar Pradesh to Delhi now.
The trauma and torture the family has undergone.
Please, my lord.
The trauma, the torture,
Yes.
the agony, and the kind of this pain.
The child and the hospitals don't treat the child, my lord. How can we in a country like ours even imagine a situation like this?
That's why we want that first of all, because they know everything that how the occurrence at the entire.
Why aren't they accepting the video recording, my lord? There is a video recording of the child where the child is seen to be alive. Why don't they take it on record?
They are referring to a video recording also. That's why we are just pointing out.
It's right here, my lord. I can give it to you. I can pass it across.
They are referring to some video recording. Is it the same thing or is it different
Of
thing?
my child, my lord. I am carrying my child.
Examine it. You are the best. With the assistance of the parents.
But my lord, they should first and foremost take that on record. They refuse to take that on record. They are going by the assumption that the child is dead at that point of time. That is the whole problem. And my friend says that no, everything is okay. Nothing is okay, according to me. It is highly disturbing, my lord.
Please try to understand what we are trying to do.
Yes, my lord.
Now they are coming out with a charge sheet which refer to some.
I will look into that, my lord. Tell them to give me a copy.
Recording, etc. They are referring to. Which video recording are they referring? Is it the same or different, or is it only a?
I will have an examination of that.
Only a kind of a just to.
An eye wash. Your lordship, tell them to give us a copy. I will look into it and I'll get back.
Just examine. As a victim, you are entitled to a copy of charge sheet. You go through it.
Very well, my lord.
After that, if you feel that there are some gaps which have been deliberately left or because of their negligence it has been left, we would like an SIT to examine.
Very well, my lord.
But if suppose charge sheet has been filed, then there is a different kind of monitoring required. Then we will evolve that mechanism.
Very well, my lord. I'll assist you on that.
But
I will assist you on that.
That we are exonerating the hospitals or.
No, I'm not saying that. My only.
Those issues will be separately examined.
Very well.
We are not closing the issue.
Very well, my lord. My anguish is that a child is not getting treatment when the child is in this kind of a state. Maybe the child would have been alive today and we would have had better evidence. We have to look at it from that aspect too.
Now, where are the two hospitals?
Yes, I am representing respondent 4, my lords. And Joseph.
Lordship, I'm appearing for R3. I'm appearing for R3, Your Lordship.
R5?
R3, Your Lordship.
Three. That's it. Say in purported compliance of order dated 10th April 2026. A status report has been filed. Is it signed by someone?
ACB.
The additional commissioner of police, my lords. At page
Each page is signed.
21, my lords.
Has been filed by some assistant, has been filed by an assistant commissioner of police. Police Commissioner Banerjee. The status report revealed that charge sheet has been filed. Before adverting to the various issues that we have briefly flagged in our order dated 10th April 26. We direct the police authorities to supply a copy of the charge sheet to the victim's family.
Along with that CCTV, my lord, which they are, the coverage that they are saying, so that I'll be in a position to compare. Because my reading is that it is a CCTV of the location which they are trying to show.
That's right, my lords. It's the CCTV.
Yes, so it is not that video recording which I am trying to give to them. Why aren't they taking that?
If there is any recording available with the my lords complainant, we can do additional.
He has been trying to give it to them from day one. They are refusing to accept it. This is what I am saying.
There is a CCTV footage.
Yes, my lord.
Which they are relying upon.
That CCTV footage is, my lord, at the time when they went to the site.
Which was the accused taking the victim, my lords?
The accused has gone and effected a recovery where they shoot the victim on the accused on his legs. It is of that period that they are trying to give. But this relates to the time when the child was recovered and the father had taken the child from there on a motorbike to the two hospitals.
Look into the documents and electronic material they supply to you, and then you make a response to us.
Very well.
So that.
Very well, my lord. All I am saying is let them give that CCTV record to me.
Yes, madam, you can also look into it and closing the assess.
I agree.
If necessary, further investigation can.
Well, that's what I'm respectfully submitting. If there is anything additional, we will carry out additional my lords investigation.
Family. Post the matter on so date for further consideration. Meanwhile, the first number 3 and 4 hospitals are also directed to file their respective affidavits. In response to the allegations made against them. No further adjournment in this regard, no further time shall in this regard be granted. Post the matter for further consideration and so on.
Well, as would your lordships desire us to carry out further investigation on material that is supplied by?
No, who will carry out that further investigation
That is the issue.
So your lordships will hold our hands, my lord.
We have exonerated them, their conduct is
I bow down, my lord.
under serious doubt.
I bow down.
We have serious doubt on their bona fides, the way they have acted. But today we don't want to comment because it may, unfortunately, if we comment to anything and charge sheet is found all right, then it may prejudice the party. So therefore, we have to be very careful in observing anything.
So, my lords, we'll hold our hands now, my lords. So, my lords, we'll hold our hands now. Whatever investigation we have done so far, that we have brought the certified copy of the file, my lords. Otherwise, if your lordships desire the original file, it will have to come from the court, my lords. The court has given us the certified copy. Otherwise, court has taken cognizance.
No, we are not insisting on the original file. You can give us a certified copy. We have no issues.
Yes, to my colleagues, I'll give copy of the certified.
Give us a copy of the certified. That is good enough.
Title to these copies.
Yes, my lords, they could have taken it, my lords.
No, I happen to be the complainant. The entitlement is to the accused.
No, entitlement is to all. We have supplied copies for you also submitted in.
207 is in relation to the accused, not to the complainant.
We'll give you, sir.
Next Monday.
Next Monday, Malad? Because I don't think your lordship is free in the.
Sabrimala.
सब कुछ है नहीं, कुछ शांत रहे. Very well, Malad. So grateful.
My lords, your lordships would desire the presence of the commissioner. The ACP is here, my lords, the SHO is here.
We will not comment on today. They are reluctant in this matter from the very beginning. Reluctant in investigation, reluctant in FIR, reluctant in court assistance, because they are known for it. They wanted to become themselves unfortunately, we can't say something in court.
My lords, I'll leave it at that. I'll assist your lordships, my lords.
If they want to come, they let them come. If they don't want to come, let this enjoy their privileges. But if they invite some stricture, then we will not hesitate. I will pass it in open court. They should be aware of this thing.
I'm grateful, my lords.
Grateful, Malad.
Item 60. Notice for Swansea.
Sorry? Notice. Notice, very great. Some returnable date.
Because I am accepting notice in item 16.
Very well.
Item 16:16.
60. May I request for a short date in 16?
We always give a date.
That's very well.
Please, Mullah.
Item 16.
Yes, Mullah.
Yes,
I'm sorry, Mullah, I was not there for the first call, Mullah. This is a serious issue, Mullah. 2014, Mullah, the states have been bifurcated.
How in interstate dispute, how the writ is maintainable?
Mullah, because finally it was the Union of India to do it, Mullah. And because both states are involved, Mullah, they both are fighting, Mullah. What has happened? There was a committee formed.
So therefore, who are
at
you?
page 69, Mullah, the committee sat. Would my lords kindly see that? The committee finds that on 53 PS.
In a case of interstate dispute.
Yes, Mullah.
Who are you?
Mullah, I am one of, this is an organization of the citizens, Mullah, who are the taxpayers, Mullah, who are finally interested to.
Every resident of Telangana, every resident of Andhra is also entitled to come. They will say, we are also citizens, we are also residents of that state.
Mullah, he is a person of Andhra Pradesh, Mullah. Mullah, the same issue is pending before your lordships, Mullah. The Andhra Pradesh has approached this court, Mullah. May I just pass on where notices are issued, Mullah? And the same issue is taken up.
No question. Don't take the question. If you entertain this kind of reputation, there is no end. You want to defeat the constitution scheme itself.
No, Mullah, we are not, Mullah. We want that it should be implemented, Mullah. And therefore, would Mullah, may I just indicate annexure P4, Mullah, for a moment?
We are on the locus.
Yes, Mullah.
Who are you? To raise an interstate dispute.
Yes, Mullah. Mullah, this organization is by the persons, Mullah, who are the taxpayers, Mullah. We are finally saying, Mullah, because these are the assets of the state, Mullah.
The issues sought to be raised in this resolution emanate from provisions of the Andhra Pradesh Reorganization Act 2014. Those disputes are essentially between Union of India, state of Andhra Pradesh and state of Telangana. It was issued. Essentially revolve around the provisions of Swansea Act. The issues essentially being interest to dispute, the petitioner has no locus standi to raise this issue. The petition is accordingly dismissed as being not maintained.
Of
and
land.
on the maintainability.
Of land.
Sorry. Item 51. Mr. Parmeshwar.
My lord, he's just outside.
वो कहाँ गया हमारा?
Sorry, let's. Let's. I mean, your lordships have directed us to classify this matter. There were about 800 applications, but there are not 800 matters because every.
Now, this is your brief note or another petition before us?
Plus, I'm saying 800 matters, unlike the MC Mehta matters, these are matters across India.
How to dispose of this matter?
Plus, there are three suggestions, Millards. There are 800 matters, 800 IAs, but 800 IAs do not travel into 800 causes of action because each matter comes with an IA for intervention, implement, exemption, etc., etc. So we have now broadly classified into 7 or 8 categories. There is an entire set of miscellaneous categories, Millards, because of the last 30 years of matters, because these are IAs pertaining to one-off state matters. There's an IA, say, from West Bengal, one IA from Nagaland. They are not susceptible to classification strictly within a group, but broader group.
So, if going by your index, some of the IAs will be relating to protected areas.
Protected area.
What do you mean by protected areas?
Because these are protected areas defined under the Wildlife Conservation Act 1972.
So therefore, protected areas under the Wildlife
Conservation.
Act.
That's right.
Right?
That's right.
Second, determination of eco-sensitive zone and activities permissible.
That's right.
Right? Third, issue with respect to violation of forest conservation.
Well, this, may I just make a...
will be very, very exhaustive.
Because this, unfortunately, what has not been brought to the notice of the court, this is an appealable order under the NGT Act now. An order granting or rejecting forest clearance is an appealable order under the National Green Tribunals Act. The Wildlife Conservation Act is not present in the schedule to the NGT Act. Therefore, the first two categories, most of them are also matters which involve more than one state. The lordships knows most of the protected areas.
4 will be overlapping.
Again, 3, 4 is specific matters which your lordships have passed orders and said no other court shall pass orders in respect of these areas because your lordships have given categorical directions that mining should not take place in these areas. So item 1 and 2, Millards, it can't go to NGT because neither protected areas nor eco-sensitive zones are technically notified under the National Green Tribunals Act. Item 3, Millards, is clearly any order passed under section 2, and your lordships have also clarified, Millards, that the High Court's jurisdiction is not taken away merely because the NGT tribunal is there. So item number 3, all matters pertaining there, Millards, actually there is an alternative forum that is available. 5, 6 and 7, Millards, item 6 is the largest bucket among the 800 IAS, Millards. It's issues with respect to Aravalli Hills and Ranges. Because this, my submission was, it must actually
go with that.
That's suo motu which your lordships have initiated. Plus item number 7, Campa Fund.
Why don't we do one thing? Serial number 5, notification, identification, mapping, encroachment and forest area. Something will be referable to number 2, other will be referable to 3, or some left out might be referable to 4. And in any case, There may be a notification pertaining to mining, the other may be regarding felling of tree, the fourth may be on the ecosystem, sensitive zone.
Each and every application go.
They will not be substantial.
5, after dividing into parts, in the other head, where that part belongs to.
Very well. I understand very well. Let's. Item 5 is the one which we are also facing the maximum problem because the oldest IAs are also in the bucket of item 4 and item 5. The others are IAs which we have mapped out entirely. There are IAs from 2000, 2001.
Delhi Ridge and this ornithological ridge.
Yes, Milas.
This issue in MC Mehta also there is a Delhi matter.
Yes, Milas. Yes, Milas. Yes, Milas.
So one is we are dealing with Godavarmal, the other dealing with here. Why not we to mix that?
In fact, there's a last order. Your Lordships also passed an order in February 2026 asking the government to file a detailed affidavit so far as Delhi region morphological ridges. Your Lordships will recollect, your Lordship, 16th March, your Lordships had said.
So that CAQM matter.
No, not CAQM.
The other matter.
In the
MC matter.
Other MC matter and in the forest matter also, your Lordships have passed an order saying that the multiple forums should stop and there must be one committee. On the previous occasion, your Lordships had something to say about the composition of the committee. Your Lordships, I think, wanted it a little more broader in perspective. Your Lordships recollect because your Lordship said the ridge areas are nothing but the starting point of the Aravallis.
I have also in one of the in MC Mehta provision.
Yes, in the air pollution matter, 13029.
Bifurcation.
Yes,
You have also
bifurcation.
Yes.
You have also last time given bifurcation.
Yes, Your Lordship. Yes.
Where some of the matters, I still recollect some of the matters you have even recommended to those can go to Delhi High Court.
Yes, which could go to the high courts. Whatever were to be infructuous were also to
Very
be.
small part of that.
Yes.
Rest of course divided. Better you also have this note. And can you have a sitting together?
We'll do that.
In MC Mehta amicus and this amicus.
We'll do that.
So, Malad,
Certainly, Your
MC
Lordships.
Mehtas. One, my colleague is amicus with.
We will give you the written number.
Then Guru Krishna Kumar sir is amicus.
That is 4677.
The ridge matters come in that.
MC Mehta, which pertain to largely Delhi or the Forest Conservation Act in this part of it.
Yes, ma'am.
There are so many other issues also which need not to. Our idea is that instead of overlapping in two postings, going on only because the nomenclature or caption of the party is different, let it be under one matter. That now we are closing the old matters and creating new numbering. So let it be a one.
Lordships, our matter is slightly different. It's on air pollution. His will probably overlap with the other MC matter.
The other one,
which is
which
4677.
Kumar and Ms. Anita Shenoy.
CAQM is separate.
Yes.
CAQM is separate. There is other MC Mehta.
That's 4677.
That is
With petition
4677 with Mr. Guru Krishna Kumar and Anita Shenoy.
This is 4677 of 85.
Yes.
Because the grievance was originally only with respect to union territory of Delhi. Unauthorized industry is heavy and noxious units, and then this forest issue also.
Malad, if your Lordship so desire, we can have a joint conference with all the three amicuses. In fact, there is a fourth MC Mehta concerning Taj matter, where Miss Liz Matthew is the amicus, Malad. So we can have a joint meeting with all three amicus.
In fact,
we'll do that.
We represent the government in all of these four matters, Malad.
Madam Liz also last time, she also recommended the same thing.
Yes, yes. Miss Matthew has also filed a note.
So all of you have a meeting and then give some common joint suggestions that which matters MC Mehta and Godavarmal can be mixed up and taken up together.
Very well.
So would your Lordships keep a common date for all of these four matters, Malad? There are three MC Mehta. Even the Taj can be taken.
How many MC Mehta we have closed 2 matters?
3 Malads.
Or 3 we have closed.
3 MC Mehta and Godavarman.
But after closing, we don't want to list them with the same nomenclature.
It's not closed yet.
Yes, orders are yet to be, seen the orders as yet.
Not as regards that.
Let's,
Not
look,
with
what we'll
regard
do is
to-
we'll sit with the registry, perhaps one of the law clerks also, and then we'll work this out, Milaj, because I think they've also done some categorization at their end. So what we'll do is we'll pull our notes together so that this note is a much more refined note, Milaj. We'll do that.
Lord, with regard to the eco-sensitive.
Another one.
Lord, with regard to the eco-sensitive zone, Lord.
See, matters, our orders are also almost final. And maybe that very soon maybe tomorrow, tomorrow day after we'll upload. Tomorrow day after we'll upload those. I think that those will also bring some clarity. And that will help you in focusing on this matter and on the left out IS there, and to tell us in which group then they will fall.
Very well, very well. We'll do that, please.
Lord, with regard to the eco-sensitive zone, I wanted to point out, there, Lord, the dispute is not only this, that in terms of there are 3 judgments passed by your lordships in this very matter, setting out guidelines as to what are the guidelines on the basis of which the eco-sensitive zones have to be declared. Now, it is only that, not implementation of that. I have appeared for the state of Uttarakhand. We've written to the central government. Central government has given it now. Draft proposal will go.
You are appearing for?
So I am appearing for the state of Uttarakhand, Lord. Now, what will happen is the draft notification will be published by the central government, and thereafter the final notification will come. So technically, it can be monitored by the High Court as well. Why eco-sensitive zone?
What is the
Lordship, please.
So Lordships, I had a slightly different, appearing here on behalf of an applicant in item 51. There's a large-scale deforestation taking place in Maharashtra. We have apprised the amicus also. We filed this application. We are requesting your Lordships to consider requesting CEC to examine the matter and present a report. Clearly, forest areas which are being deforested, completely, the trees are being felled recklessly. It's shocking. We have some pictures. It's a fresh matter. If that could be taken up on some priority.
We'll list it. You give us the number, we'll list it.
Very well, your Lordships. May I give it to the court master? I'll give it to the court master.
Yes, we are in any case listing these matters after 2 weeks, maybe that on that day we'll list it.
If it could be taken up anytime this week, your Lordships, if it's possible. We only want a report because every day around 12 to 15 trees are being felled, your Lordships.
Well, see, right now, our hands are overflowing.
Very well. Grateful, your Lordships.
Yes, item 52, 53.
Yes.
It's in 53. Sorry.
Malaz, we have an interim report on behalf of the NIA, Malaz. Lordships had directed NIA, Malaz. So the interim report is there, Malaz, if your Lordships like to. Sorry.
Yes, ma'am. Please.
You see, regarding that, on that day,
Yes, Malaz.
Sixth April order. 6th April order.
Malaz, we like to see from page 7, Malaz. Progress of investigation.
which part you want us to read?
Malaz, page 7, your Lordships will see what is the update, Malaz. We have pointed out, Malaz, what is the investigation we have carried out. Site inspection, etc. Witness examination is at page 9. Digital evidence we have collected, Malaz, para 21, 22. Technical analysis is going on, and the further arrests that are made are at para 28. And your lordships will see the conclusion in para 30, my lords. So, my lords, we'll continue our investigation, my lords.
I think one is para 25.
Yes, my lords.
Very important, the very opening line.
Yes, my lords.
Not the, just wanted to add, not that we, whatever cooperation they wanted, the Home Secretary was written to, we've given it. And they've asked for some additional material, which we have, again, which letter came yesterday, whatever they want, additional security.
My lords, that was also there in our status report. We have received cooperation from the state, my lords.
In the next phase of investigation,
Yes, my lords.
we would like this, like some of the persons illustratively you have identified in para 28.
Yes, my lords.
Like to specifically know,
Yes, my lords.
is there any political background of these people?
Yes, my lords. In fact, the third person is the key conspirator. He's only been arrested yesterday, my lords. So we'll, my lords, present the IG NIA is here, my lords. She has signed the status report.
We don't want to leave this matter like an academic exercise.
You bow down, my lords.
We'll take it to some logical conclusion.
Please, my lords.
Lord, just one thing, in terms of your lordship's order, oral observation, the Home Secretary, the DGP, and earlier the Chief Secretary have all met and paid their regards, not met the Honorable Chief Justice of the High Court.
No, they have filed their affidavits also regarding.
Yes, but that's an oral observation. We had to comply with it. We've done the needful.
Nothing. We don't carry grudge against individuals or anything. We only sensitize them, and now Chief Secretary says that he has taken up the matters where the additional security has been provided. But we have received one communication from the Chief Justice of the High Court today in the morning, and this we would like to read out completely because it deals with both issues. Where he has said, under the direction and supervision of the Honorable Bench presided by Your Lordship, we started the SIR exercise in the state of West Bengal in last week of February 26. The Judicial Office of the state, with the assistance of Judicial Office of Jharkhand and Odisha, have completed the Herculean task of deciding more than 60 lakh objections in the SIR process in the first week of April 2026. The exact number of disposals are depicted in the following chart. Now, total objections were 60 lakh 6,675. They have decided 60 lakh 4,885. What is left for technical reasons, they say, are about 2,000. That is 1,823, which is 0.03% only. And e-signature also, almost 60 lakhs were over. Maybe that left remaining also. That, Mr. Naidu, you might be knowing. But anyway, then the Honorable Chief Justice pointed out that in terms of order of 6th April 26, he constituted a committee of 3 former Chief Justices or judges to establish the procedure that will be consistently followed by 19 appellate tribunals without any delay, and to endeavor to have the procedure prescribed by 7th April 26 to accelerate the resolution of the appeal. In the late evening of 6th April 26, a committee was constituted presided by Chief Justice, former Chief Justice T.S. Yugananand. Then he has pointed out the honorable judges of the committee prepared a standing operation procedure SOP to be followed by all 19 appellate tribunals on 7th April 26 as mandated by our order. Then based on 10th April 26, a team of the High Court made an inspection of the venue as regard the preparations to house the appellate tribunals. The team reported some minor deficiencies were there. Since it appeared to be ready to be functional, on Sunday, yesterday, the 12th April 26, a portal introduction session and interaction was organized in the presence of Chief Justice Committee members, both the former Chief Justice of the High Court at Calcutta, who are now members of the Appellate Tribunal, and other former judges of the Appellate Tribunal. The same was followed by a working lunch. 17 honorable judges joined the session. They were introduced to their team members. They took first-hand experience of handling the appellate portal. Thereafter, in the interaction, the honorable judges of the Appellate Tribunal have discussed about the modus operandi to be followed and decided to start functioning from today. That is, today morning they have started. Now, two areas. One is security cover requires to be provided to the judicial officers of the state who were engaged in the SIR exercise. So we will simply direct that this security arrangement will continue till further order. At least till all the elections are over in West Bengal. We would like our officers to be protected.
True.
As per the feedback from the Election Commission of India, 34,35,174 appeals have already been filed. The disposal of appeal will obviously will consume some time.
Well, just request a figure to be repeated. That
Before we come to the issue, hearing, just write down. We have received a memo dated 13th April, a given letter dated 13th April.
Please, wait a second.
The due letter dated 13th April 2026 from Honorable Chief Justice of High Court at Calcutta. It is imperially pointed out that in compliance to the orders passed by this court, the SIR exercise in the state of West Bengal was commenced in first week of February 2026 by the judicial officials of the state, with the assistance of judicial officers of Jharkhand and Odisha. The Herculean task of deciding more than 60 lakh objections in the SIR process has been completed in the first week of April 2026. To be precise, Honorable Chief Justice has pointed out that 50,06,675 objections were required to be verified, out of which 60,04,852 have since been verified. Only 1,823 are left, are pending due to technical reasons. Similarly, the exercise of e-signature has also been to the extent of 99.69% has been completed. That's all. And the Chief Justice has further pointed out that in reference to our subsequent order dated 6th April 2026, a committee of 3 former Chief Justices of judges was constituted to establish the procedure to be consistently followed by all 19 appellate tribunals which have been constituted to decide appeals against the orders passed by the judicial officer while deciding objections. He further explains that the 3-member committee has prepared a standing operation procedure SOP which will be followed by all the 19 appellate tribunals. PO letter informed that yesterday, that is 12th April 2026, a portal introduction session and interaction was organized in the presence of Chief Justice, committee members, and the former Chief Justice of the High Court, and other members of the appellate tribunal. The Honorable Chief Justices, former Chief Justices, judges who constitute the appellate tribunals were introduced the first hand experience of handling the appellate portal. And they were apprised of the procedure to be uniformly followed so as to enable them to decide functioning from today, that is 13th April 2026. Next paragraph. We place on record our acknowledgement and appreciation for the nearly impossible task which Honorable Chief Justice of the High Court has come up with the able assistance of the judicial officers of State of West Bengal and the neighboring states have completed. The information given to us from time to time undoubtedly revealed that how difficult it was for the judicial officers to undertake the task for which they worked even on Saturday, Sunday, without taking any leave. Honorable Chief Justice also without causing any while performing his judicial duties in the normal course of continue to devote extra hours for the purpose of constant monitoring and ensuring that the assigned responsibility was completed smoothly. We equally appreciate the zeal and enthusiasm with which the judicial officers have also performed their duties. Next paragraph. We have no reason to doubt that the former Chief Justices who have graciously agreed to be part of the appellate tribunals and to whom the first-hand experience of handling the appellate portal has been introduced, will also be able to complete their task within a reasonable time. And all stakeholders will continue to extend their cooperation to them in this regard. Next paragraph. The new letter sent by the Lord Chief Justice also highlight the areas of concern, first of which being the security cover required to be provided to the judicial officers of the state who were engaged in the SIR exercise. In this regard, we direct the state government, we direct the Union of India as well as the state government to ensure that direct the Election Commission of India as well as the state government to ensure that the security already provided to the judicial officers is not withdrawn and or assess further threat and perception to them and deploy for additional security if so required. It is made clear that the security cover given to the judicial officers shall not be withdrawn without prior permission of this court and in any case till the entire election process is over.
But some have gone back to their states.
The deployment of central forces in terms of our order dated, it was 1st or 2nd April.
Second.
Passed on 2nd April 2026 will consequently continue till further orders.
Let some of the judicial officers have gone back to their.
Isn't it first statement?
Some of the judicial officers have gone back to their respective states.
Then you know, that's only because those who are working in West Bengal.
Only those who are working, Lord.
Lord, the deployment of the vulnerable areas may also continue. Let it be at the behest of and monitored by a monitoring committee, and the ECA may do it. Otherwise, my Lord, the post-poll violence which was witnessed in 2021 could be repeated, and it is a deterrent, my Lord, on a free and fair, peaceful elections even in 26.
That security will continue.
But we have some certain things.
Vulnerable areas as identified by the ECI, let them do it.
Malad, we
That
have
is a matter
certain
for
things
it.
to say.
Lordships could issue the
Malad, we
ECI
have
to do
certain
that.
things to say. Malad, here, this is, please, madam, please, kindly see, Malad. Say
That
to your
look into
lordship
your counter
that,
and then.
This issue there.
Malad, kindly, kindly,
Is there any dispute on this?
Malad, kindly bear with me.
No,
My Lord, there is no dispute on these issues.
No
No dispute.
Please listeners, on this issue there can't be any that that's all we have said, only this much right now.
Taken over by the Delhi police. We have no dispute.
So
Let them
ECI or the state government, whatever.
all investigations also. Normal investigations. Election Commission has directed no investigation would be made only by the Delhi police and the other polices of the different states. We don't have any objection.
Compliance to our
Emergency.
in compliance to our order dated 2nd April and the previous order 6th April 2026. The Chief Secretary State of West Bengal and Director General Police of State of West Bengal have also filed their respective compliance affidavits. It is stated by the Chief Secretary that a virtual meeting was called on 3rd April 2026 in which necessary directions were issued to the police authorities, to the police/civil administration to ensure security arrangements for judicial officers. It has been further stated that the security arrangements for the judicial officers have been enhanced by including additional CAPF personnel. Next paragraph. The Director General of Police has also in his affidavit explained that a comprehensive security plan has been prepared in all districts and police commissionerate for all districts and police commissionerate for the security of the judicial officers, and necessary deployment and arrangements have been made. These arrangements include 1I, provision of PSOs, 2I, escort during transit, 3, security arrangements at place of work, and 4, enhancement of CAPF forces in sensitive districts. Next paragraph. In light of the directions issued in the earlier part of this order, among the recommendations of the Honorable Chief Justice of the High Court, we direct the Chief Secretary, Director General of Police, and other police and civil administration authorities To ensure that the security arrangements made for judicial officers, including the enhanced security given to them, is not withdrawn without prior permission of this court.
All pending criminal investigation all over West Bengal, whatever the nature of the case, and the Delhi police will investigate. This is the power of the Election Commission. Anyway, Millard, I am not on that, Millard. I am on the SIR. Kindly just hear me, Millard. I am only on the SIR.
2 minutes already, 4:15.
Millard, kindly bear. Millard, kindly bear. Please, Mr. Devan. Kindly see, Millard. Your lordships have been given an impression that all cases have been adjudicated. Millard, kindly see. Your lordships have given the impression that all pending cases have been adjudicated. And if possible, kindly see the list. See, Millard.
What do you want us to see?
Millard, kindly see. 6th April, this voter list has been published in Raghunathganj, constituency part number 196. All are under adjudication. All are under adjudication.
Only 1,820.
No, it was said before your lordships on the super first phase is concerned, everything was over. This is the first phase. This is the first phase. Now, Millard, kindly see this. And this is the one case I have, it has come within my own knowledge. Kindly see.
What do you want to show us?
Millard, the under adjudication case is still pending. That's why I am saying.
1,000.
Millard, that is the second part, first part. On the other day, it has been said before the lordships by the Election Commission Council that
Total objections who came to
Millard, this is going to be.
Mr. Bandyopadhyay, if the officers have completed their adjudication in the first instance in respect of any assembly constituencies by 9th of April, even if they have exceeded by 1 or 2 days in respect of the 153 assembly constituencies, we have given.
Well, kindly see. There are two dates are there. Well, kindly see, 2 dates are there. One is 6th April, another, kindly.
Sir, the elaboration you will make, we are giving you the answer. The 153 constituencies whose last date of nomination was 6th of April, the list was published on the night of 6th of April.
Right.
There was some spillover on 7th or 8th. Those names will be included in the electoral roll for the 23rd April elections.
6th April would be, sir.
Addition to that,
all under adjudication. All under adjudication, it has not yet been adjudicated.
May I beg you
That is has not been brought out.
Don't worry. If their names are there, they will be voting.
Yes, another
even after the appellate adjudication, they will have right to vote.
cleared by 6th.
Millard, another submissions. Millard, 16 lakhs appeals have been filed. 16 lakhs. Millard, if it is not possible to dispose of 16 lakhs appeal. Kindly allow Millard to franchise their vote.
Where is the question of voting them?
Millard, 16 lakhs are pending.
Those who have been allowed, then we should stay that also then.
Millard, 16 lakhs are.
Passed,
Millard,
wherever you are happy.
kindly see, 10th March, your lordship was pleased to constitute the tribunal. 16, Millard, 10th March, your lordship.
One humble.
In block, 16 lakh appeal will be allowed. The number is at variance. The Chief Justice's report to us is 34 lakhs.
34 lakh appeals. I couldn't hear that. I just wanted to know.
34 lakh, Mr.
34 lakh, 35,174.
34 lakh, 35,174.
As on 11th April 2026. By now
we will try to create a via media as much as responsive to the twin requirements.
Yes.
Of a first layer adjudication on one hand and your aspirational right in the appeals that have been.
So, Manoj, may I just invite
But
attention?
only
Just-
because the appeals which are allowed, they will be
First of
allowed
all
to
very
go.
grateful
That
for
is the
this figure
clarification
because I
received.
didn't hear it when your lordship actually mentioned it. The figure of the total pending appeals, which your lordship says is more than 34 lakhs. So that would include. Now, I have just one point. May I just request your lordships to just consider section 21 of the Act? Could you?
Just read out.
Yeah.
21 proviso.
21(3), I just, and the proviso.
Proviso.
Yes.
But that we've crossed that bridge.
Manoj,
We have crossed that bridge.
Manoj, I'm suggesting that with the proviso read with the statutory appeal, your lordships have of course given us.
One problem is, please see.
Yeah.
Mr. Diwan, see rule 24 of the registration of electoral rule. An interim suspension of a decision cannot be done in appeal.
Yes. No, Manoj, keep the
See the
interim.
other aspect.
Yeah.
55% objections have been rejected.
Yes.
Those, they have been included.
Yeah.
The objectors have gone appeal against that. The
Yes, you are
34
right.
lakh
That's how you
appeal.
get 34 lakhs.
Yes, they will ask for the same order.
Correct.
No,
They will also ask for the same order.
Now, Manoj,
We
therefore,
got back to the same position before appointment of the judicial officer.
Manoj, kindly,
proviso, as your lordship correctly points out, perhaps the proviso pushes the proviso, Manoj, which is the statutory wisdom of the legislature, appears at least to us to revert the position prior to the SIR exercise. Please just consider that element. If that is the case, Manoj, I would make two suggestions. One is your lordships will consider how to balance these appeals, particularly having regard the proviso to 21(3). And the second respectful submission that I have is that surely, my lords, if the appellate tribunals, which have just started functioning, I think that was the, they've just initiated. If there is substantial progress, my lords, over the next week, then surely there ought to be, my lords, please keep in mind.
That is what we are seeking to focus on.
Yes, yes. Some supplementary, my lords, list which comes out.
That we are seeking to focus.
We are also equally conscious of this.
No, I'm very grateful.
Millets, when it comes to section 21, it's an ongoing process. It goes on. When it comes to millets, freezing and finalization and the right to vote in that particular one millets, that's governed by section 23, read with the rules. Insofar as 21, nobody denies it should go on. That's what my lords have held. That the appeals, let them go on so that they'll have their rights vindicated if at all they could. And then,
Mr. Naidu, we are conscious that pending of an appeal does not amount to suspension of the primary decision. Right, that is the rule under the rules. But if an appeal is disposed of, what would be its consequence is also in the rule, that is subsection 5, that the registration officer will immediately amend the electoral rule.
millets subject to, millets.
So there,
yes.
And there, Mr. Naidu, subject to our exercise of Article 142 powers.
Millets, yes, millets. As and when your lords take up millets, we'll submit our notes, we'll submit the decisions because it has at least half a
Can I
dozen
make
times
one
considered
request
by
to
your
the lordship?
lordships.
Can I?
Not time that it is no longer recent agreement. Your lordships have considered, your lordship have laid down the law.
Milord, can I make one request that first phase appeal?
Yes.
23rd April is the first election date. All that appeals, Milord, pertaining to that, as far as possible, dispose it of by 20th
That's
or
why, millets,
21st.
on the day
That
6th, it's been
request-
finalized, they are
The
in.
way, Milord, the adjudication process, you have, your lordships have divided into two.
Kalyan, we are equally concerned about these issues.
Yes.
Let us think, because we cannot create a situation where the appellate tribunal members are bogged down and they leave everything on in the mid of it and create another challenge before us. Please appreciate that part also. So we have to, similarly, as again we are pointing out, see the second side of the consequence. There is a writ petition today before us, filed, saying that wherever the objections have been rejected and we have gone in appeal, don't allow them to vote.
Yes.
On the same analogy, they will also ask for it. So we have to think and draw a balance between.
Milord, at the end, just I say to your lordships, kindly do not take it. At the end, Milord, peoples of Bengal are not depending on anybody. They are looking towards your lordships, Milord. Deprivation is so much, only towards your lordships, Milord. Only whether 142 or what, Milord, they want to exercise their right. these 34 lakhs peoples, they are not the genuine voter. If they are not, if they are genuine voter, that is the reason 34 lakhs. They have gone there. Standing, they are towards you, not towards election commission, not towards anybody.
Bengal. Everyone knows how the demography has been changed.
Don't say about Bengal.
Yes.
Yes. Bengal.
and Bengal
Don't
both.
say about Bengal. Bengal knows how to fight.
Both the demography
Bengal
have
knows
been
how to
changed.
fight.
Allow us to think and.
Don't blame.
Would you list this on Friday or Monday?
This is just to cover fire, my lord, just to protect the
Kindly keep it on
infiltrators.
Friday or Monday.
Yes, my lord. My lords, my IA is there. We are 106 people. My lords, my appeals are pending, my lord.
That doesn't bother us.
Yes, my lord, my
We
appeals
pass
are pending.
We have considered this aspect. We
Yes,
know that what's coming from your side. We know what is their problem
please.
also. We will pass some order.
My lord, second, one other aspect.
My lord, please consider my IA, my lord.
Better on Monday or Friday, my lord.
My lords, one other aspect, my lord.
No Friday. Now we
My lords, one other
My lord,
aspect
before
regarding
23rd.
of these
My lord,
aspects.
before 23rd. Before 23rd.
My lord,
One
please.
day before 23rd. Please.
Thank you very much. Thank you.